have business with the Appellate Division. Draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon, everyone. Welcome to the Appellate Division, First Department. As presiding justice of this august court, it is my privilege to preside over this auspicious and historic occasion. Today's oral argument will be heard by the first all-black bench in this court's 130-year history, and we all happen to be women. Fittingly, this is taking place during Black History Month. I am tremendously proud to be sitting here with four of my esteemed sisters in the law, Justices Troy Weber, Tanya Kennedy, Bahati Pitt, and Marcia Michael. This day would have been difficult to imagine even a generation ago. The Appellate Division First Department heard its first appeals in 1896, 26 years after Black men were granted the right to vote, more than 20 years before women were granted that same right, and at a time when law schools were generally closed to Black people. While it is an honor for the five of us to be sitting here now, I would like to take a moment to pay homage to those who were denied the opportunity, as well as recognize the Black jurists who previously served on this court. The first Black man to be appointed to our court, or any appellate division in the state, was Justice Harold Stevens in 1958. Justice Stevens also served as the first Black presiding justice of this court and the first Black judge on the Court of Appeals. It would be another 24 years, in 1982, before another Black jurist, Fritz W. Alexander, who also served on the Court of Appeals, would be appointed to the Appellate Division First Department. He was followed by Justice George Bundy Smith in 1987, who also went to the Court of Appeals, and Justice Milton L. Williams in 1993. None of these justices who I've just mentioned was appointed while another was on the bench. It wasn't until 2008 when myself and Justice Leland DeGrasse were appointed by Governor David Paterson that two or more Black judges were simultaneously present on this court. In the years since my appointment came Justices Sheila Abdus-Salam, Darcel Clark, and the justices who join me on the bench today, Justices Weber, Kennedy, Pitt, Burke, and Michael. It is only since Justice Michael's appointment in November of 2023 by Governor Hochul that we are able to sit on this historic all-Black bench. To date, of the 140 justices who have served on the First Department, 12 have been Black. It is fair to say that when this court first opened its doors in 1896, most people would not have imagined that the court would eventually be comprised of such a diverse bench, including judges of Black, Asian, and Latino descent. As we know, a judiciary that reflects the makeup of its citizenry not only gains legitimacy in the eyes of the people it is designed to serve, but it also leads to better decision-making, where various perspectives can be considered in every adjudication. As Maya Angelou wrote, we all should know that diversity makes for a rich tapestry, and we must understand that all the threads of the tapestry are equal in value, no matter their color. I, for one, am grateful to serve not only with the judges here today, but also with my sisters and brothers on this court from so many diverse backgrounds, each of whom is dedicated to administering justice efficiently and fairly without fear or favor, bias or prejudice. I thank you for listening. And now to the business of the day, the calendar call. Understand that we have about 4.5 hours of argument time requested. We have your briefs, we have the record, and we're fully familiar with the facts of your case. So please ask only for the time you need as I call your case. People versus Kirk Patterson.
Afternoon, 5 and 1, please, Your Honor.
Sorry?
5 and 1, please.
5, 1, and 5. Thank you. B, children is submitted. Karash International versus Kim. If everyone would rise at the same time. The parties, are all parties here? Thank you. Okay. For the appellant?
10, Your Honor.
I'll give you 6, 2, and 6. If you need more, I'll allow it. Highland versus MF Contracting.
Appellant request 5 and 2, Your Honor.
Respondent MFM, request 6, Your Honor.
Respondent Tectonic, request 5, Your Honor.
Respondent City of New York, request 5, Your Honor.
5 and 2, 6, 5, and 5. Taylor Bean and Whitaker versus Daniel. And you have no opposition here. Okay, I'll give you 2 minutes. Thank you. 1650 Broadway versus Sturm. I'll give you 5 and 1 and 5 and let me just check for a moment, please. I don't see this as a cross appeal. So, okay. 5 and 1 and 5. Valley National Bank versus TDS Cab Corp. 5 and 1 and 5. Valenti versus the MTA.
Appellant respondent, Jason Lawrence, would request 5 and 2, please, Your Honor.
Defendant, respondent, appellant, Mr. Smith and building materials, 5 and 2, please. Appellant, Douglas and Charles, I'm going to my co-plaintiff.
So that was 5 and 2. So you'll share that time.
Respondent, DBTA, MTA, also known as Bridges and Tunnels, 2 minutes.
Third party defendant, second, third party plaintiff, respondent, American Bridge, 2 minutes.
Okay. Appellant 5 and 1 for the plaintiff 5 and 2, Smith 5 and 2, and that's a shared time. TBTA 2 and American Bridge 2. I think I got everything there, right? Okay, thank you. People versus Jamal Foe.
Appellant request 6 and 2, please.
5 and 2 and 5. Tantaros versus, oh, I'm sorry. Okay, People versus Jamal Foe.
Appellant request 6 and 2, please. You said 5.
And I said 5 and 2 and 5. Okay. All right, now we're ready for Tantaros versus Kretschmer.
Appellant Mr. Kretschmer, request
I'll give you 6 and 2, and again, this is not a cross appeal. And 6. Offshore exploration versus De Jong. This is a cross appeal. I'll grant that request, even though we have thousands of good lawyers, excellent lawyers in the First Department. I'll give you 7 and 2 and 7 and 2. First case for argument is People versus Kirk Patterson. Just a moment. You may begin.
Good afternoon, Your Honors. Nathan Brown for the appellant, Kirk Patterson. It's an honor to be here today. A SORA hearing is focused exclusively on 2 elements: an individual's current risk of sexual reoffense. The court below erred in assessing 10 points under Factor 13 because the offense that occurred was too far in the past to be considered demonstrating his current risk of sexual reoffense.
Haven't we already decided this issue in People versus Stewart, where there was a very similar fact pattern where the individual was out on parole, I believe committed 2 murders, and then was incarcerated for a very long time before going before the SORA board?
It's our position, Your Honor, that the recency, I don't recall how the court below ruled on it in Stewart, but here the court relied strictly on, or did not consider the recency of the offense, and viewed it as sort of a strict liability type situation. And our position is that that would conflict with the overall framework of SORA, the internal instructions of Factor 13.
Well, I'm sorry. I thought your argument was that the 25-year lag was too remote in time. Is that not your argument?
That's correct, Your Honor.
So in Stewart, what we said was that we rejected the defendant's argument that the murders were exceedingly remote in time. 25 years.
Okay.
So as the PJ just stated, why should we now in any way reject Stewart or not abide by our decision in Stewart?
Your Honor, I would just submit that I don't think that decision in Stewart correctly interprets the guidelines position on assessing a non-sexual offense.
And
How do we
also
not
what we said in
follow it, though?
Stewart was that the guidelines contain no time limits.
Yeah, and again, I would disagree with that, Your Honor.
But we
main
have
reading of
case
Factor-
precedent here from this very department. I think that case is 2023. How do we ignore that in light of what you're saying? I mean, you have to make some very clear distinction. I don't see what that distinction is here, given that the time factor was the same issue there.
You're right, Your Honor. I apologize. I think that I may have missed Stewart.
It's 217 AD 3509 from 2023.
And let me just add that leave was denied, 40 New York 3rd, 909.
Okay.
So, counsel, why don't you maybe focus on your second part of your argument?
Thank you, Your Honor. As I was just going to move on. We also believe that a downward departure was erroneously denied. Mr. Patterson presented a preponderance of evidence to demonstrate that his risk of reoffense was mitigated by several factors that were not considered by the guidelines. Those include his advanced age, his treatment, and his strong
55.
family support.
He's 55.
I don't write the research,
I'm
Your
just
Honor.
saying, 55. You know, I just celebrated a birthday last week, but I don't know, is 55 an advanced age? And what do you have to back up the statement that, you know, this advanced age of 55 is going to be that he's not going to reoffend?
Well, first of all, happy birthday, Your Honor.
Tread lightly.
I don't write the research, Your Honor. I only submit it to this court, and that research demonstrates that beginning at age 50, there is a precipitous decline, not in a person's physical abilities, but in chemical processes that go on in a person's body, and not that they would be, and these processes don't indicate, you know,
So
some
you're
level
not
of
saying that
disability.
he no longer suffers from mental illness. Are you saying that his mental illness is somehow lessened by, I mean, my understanding from the record is that he was very compliant. I don't know how long because it didn't indicate how long he's been compliant, but that he's been compliant with medication, and so that should be a reason for also not applying the extra points. But you know, the problem is that people who have mental illness or any illness where they don't take the medication sometimes fall into the trap of having that illness reoccur. And it's very common with people who have mental illness. So how can we rely on that as a basis for saying that his age somehow makes his ability to comply different?
Well, those are two separate things, and if I can finish on age and then move on to your question, Your Honor, I just want to identify the three primary factors that the research identify relating to age. They are an increase in impulse control, certainly not a factor of disability, but a inherent element of age, decreasing sexual desire, and the changing circumstances in a person's social community that is inherent with an individual and their community aging. So that these are not factors that go to a person's, you know, disability, but they go to just natural processes that the research describes as inherent with age.
How does that dovetail with the issue of your client's mental illness?
I'm going to let you answer that question on rebuttal.
Okay, thank you, Your Honor.
Good afternoon, Your Honor. Hunter Barron for the people. Just starting with the downward departure issue, just want to emphasize that defendant's conduct in this case was extremely serious. He robbed and raped a woman while brandishing a gun and as part of a string of robberies. And then after he was released on parole, he committed a particularly heinous murder. And it's our position that none of the mitigating factors that the defendant has raised justify disturbing the court's decision below and outweighs that extreme risk to public safety. So unless the court has any further questions or perhaps on the point.
Well, if you could address the mental illness issue, the defendant argues that he exhibited an exceptional response to mental health treatment.
Yes, Your Honor. Well, as the court below put it, defendant's merely beginning a journey of treating and addressing his mental health problems. He just was released from prison, and so for that reason, the court, didn't feel comfortable granting a downward departure request when he hasn't demonstrated that his risk of reoffense has been minimized or decreased. So, unless the court has any further questions, thank you.
Thank you.
Counsel, if I may, over here. The age, because I fall in that age range as well, but we won't talk about
I'm
that.
approaching it myself, Your Honor.
So, well, let me ask this question, because this court has ruled many times that, quote unquote, advanced age, right, in and of itself does not warrant a downward departure. So let's take that and then couple it with the fact that in instances where there's been some evidence that the age, along with some type of physical limitation, some medical issue, would make it less likely for a defendant to reoffend. So my question to you is, besides the studies, what, if any, evidence did you present to show, there's a medical condition or some type of physical condition coupled with the age that would make it less likely for the defendant to reoffend?
I think coupled is the right word that Your Honor is using there, because the guidelines make clear that those are two separate factors. A person's age and their physical ability are two separate factors.
I know.
Here, I'm not aware of any physical ailments that he has, but addressing the mental health side of his circumstances, Mr. Patterson has what docs refers to as a serious mental illness, and because of that, he's been receiving, not recently, he's been receiving 4 years within the Department of Corrections comprehensive mental health treatment that continues while he's on, after his release. The letter from his case manager referred to some of those treatment programs, drug treatment, mental health treatment, and he continues in those programs until it is determined by the Department of Corrections that he is no longer needs that level of supervision or that level of treatment. So I think there are considerable safeguards in place, as well as his lifetime parole from the parole conviction, that are there to help continue this mental health treatment that addresses the underlying causes of the offenses, and I think warrant a downward departure in this case. Thank you, Your Honors.
Thank you. Thank you both. Karash International versus Kim.
May it please the court, James Chu on behalf of the appellant. Your Honors, the motion court's summary judgment decision declaring the note balance was zero and dismissing all of appellant's claims was erroneous.
Why was that erroneous when we have a written agreement, the consulting agreement that Mr. Kim signed?
Well, Your Honor, I'm addressing actually the balance of the note, but I can address the consulting agreement if you wish.
Okay, so with regard to the balance of the note, wasn't there a no recourse clause in that consulting agreement that then once the amount went below a certain value, he was only entitled to shares?
No, Your Honor. So the no recourse provision in the SPA actually does not make a lot of sense in light of the structure of this transaction. The structure of this transaction was that Mr. Kim sold his company.
I know what the structure is. I know he sold his company, but the question is what he signed. The no recourse clause was in the consulting agreement, wasn't it?
There was a note recourse provision, correct. But the way that the...
And it was in the agreement?
It was in the agreement, but there were also...
And he signed the agreement?
He signed the agreement, correct, Your Honor. But
and he had a lawyer?
I'm sorry?
He did have a lawyer present?
He did have a lawyer. Okay. But there were also provisions in the note and an amortization schedule that contemplated repayment of the note. And so there is an obligation to pay the note under that contract.
So what are you arguing is some ambiguity?
Well, the contracts admittedly have some ambiguity in them, which is why the intent of the parties in this case is particularly important because there is a claim for the breach of the implied covenant of good faith and fair dealing, which informs a lot of the issues in the case and a lot of the claims.
Counsel, what is ambiguous in the contracts? What terms are considered?
Well, Your Honor, for example, why is there a non-recourse term in the SPA when the structure of the agreement also contemplates that he would perform so that he could continue getting paid under a note?
But it said, but also in that was that no recourse clause, and it also said that he could be terminated without cause as far as his work was concerned.
Fair point, okay. And let me address that in two ways. First, I go back to the implied covenant of good faith and fair dealing. This is critically important because the exercise of the non-recourse provision did not occur until well after she took commercially unreasonable steps to tank the value of the company, and then 5 years into litigation, try to then turn back the company. That's fundamentally unfair. With respect to the termination without cause, there is a provision, and I'm not here to suggest that she did not have the right to terminate him without cause. She did. We are conceding that. But the First Department case law teaches us that even in the face of an unfettered discretionary right, the party exercising that right must do so subject to the implied covenant of good faith and fair dealing, meaning she cannot act in a way that will frustrate the purpose of the contract. The purpose of the contract.
But what
the
would the
expectations
purpose,
of
you're
clients.
saying the purpose of the contract was to allow Mr. Kim to continue to run the business so that it would be run properly and it wouldn't lose money and it wouldn't go into the ground, right?
Correct, except that
Okay.
when she took him out of the equation, there still is an expectation that she would act commercially reasonably so that his earnout would be protected.
But she said that, I mean, that's just a matter of course, there was nobody, she couldn't run it. I guess she was running it. She wasn't capable of running it, and she couldn't find anybody else to run it. At least those are her claims. But what remains is that she could fire Mr. Kim for no reason or any reason. I mean, that is really the point here. I don't see how you get
Agreed,
to the good faith and fair dealing as a separate cause of action, given what was contained in that agreement that he signed.
Agreed, but there are several contracts here.
Well, Counsel,
implied-
I'm glad that you started off on that because that's actually my point. While there were several things leading up to this particular agreement that was signed, this agreement contains a clause that this is the entire agreement. This is what is going to govern. Nothing else that maybe might have come before really matters. And I think that our case law supports that. So I'm just wondering how you get around that.
Okay, the merger clause that you address is a very general merger clause, and we do address that because there's case law that holds that in such a case where there's a general merger clause, it doesn't necessarily prevent the parties from addressing some of the conflicts within the agreements. But the important point here is what I wanted to address was because there are several contracts and they interoperate, and because she did, and the court found this, she slipped in the without cause provision fraudulently, but
But
again,
he signed it. I mean, one is assumed to read the things that you're signing, the documents that you're
agreed.
signing.
I'm not
You can't
disputing.
slip in something where it is where the person reads it and signs it. I mean, I could understand your argument if perhaps after he signed it, she added the clause, but it was there when he read it and when he signed it.
Agreed.
So
I'm
you
not
use the
challenging
term
that.
slip in, and you're not challenging that. What is the point you're making
My
by all of
point
that?
is, there are several contracts here. The implied covenant doesn't just arise from the consulting agreement. It arises from Section 2.5 of the SPA, where there was initially a mutual expectation that this company would maximize profits for the benefit of the appellant and for the benefit of the respondent, right? So there is a mutual benefit. So when Mr. Kim was removed from the equation, there's still an obligation under the law. The Marblegate decision that was just provided by this court last year teaches us, as well as Rishbell, as well as Trailwinds, as well as Hirsch, all First Department cases, teaches us that when you exercise the discretion, you still have to use commercially reasonable means to ensure that you don't frustrate the purpose of the contract. Purpose here is to make money. It's a for-profit company, and therefore the purpose is to maximize profits. She should have taken steps to try to maximize profits, but there's a litany
Counsel,
of bad faith conduct.
Counsel, if I may, over here.
I
You
see
know,
that my time is
no,
up.
no, but you're going to answer my question. You know, this stock purchase agreement is so clear. There's no ambiguity, and all this other stuff, I'm not sure where it's coming from. The bottom line is he's sophisticated. He was retained by an attorney, he retained counsel. If he didn't read it, that's his fault. But it's so clear.
I understand, Your Honor, but I think Your Honors are focusing on the consulting agreement and the fact that he missed the without cause
Okay, so you
termination.
can try to convince us again on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. I think you've already touched on a lot of what I was going to say. The contracts are not ambiguous in any way, shape, or form. It's very clear.
What about, you know, there is, okay, I mean, he's correct. He uses the word slip in. Unfortunately, that's to his client's detriment. He didn't read it, but it certainly doesn't seem like it was, you know, done in the best way. But he was there. He should have read it. He should have read the document. Let me ask you this. There is money that is exchanged under the note. He has no recourse, and they're just the shares. But I think there's some money that is withdrawn with regard, and there's a question as to whether it is an equity distribution or whether it is a loan. What's your view of that?
Sure. So if I may just, there's no evidence of any slip-in. It was put in the contract, so I'm not sure where that comes from.
It was, that's the word he uses. I understand why he chooses it, given the way, you know,
Sure.
it wasn't in anything else until I think the night before or the morning of. But in
Well,
any case,
I'm not
moving
even
along.
sure that that's the case. But to answer your question about the loan to stockholder, so that's on a trial balance sheet that was created by Mr. Kim when he owned the company. It's a term that's used in a QuickBooks program. It's misclassified just because his accountant put in loans to shareholders doesn't make it so. And I think we know that from the testimony of the accountant, Mr. Bressler, in the record at
Counsel,
12:30.
what evidence do we have that it is a loan, given that it was for a tax payment on an S corporation?
Right, I don't think it's a loan at all, right? It's clearly a distribution. He took the money to pay his taxes. If it were a loan, he'd have to pay it back. And at what point would he pay it back after he sold the company? So effectively, calling it a loan means he increased the purchase price, which is the very point.
So you're saying it's improperly indicated on the document? That's what you're saying?
Correct. It's a QuickBooks, and somebody typed in
And
probably
we should
because
take
Mr.
that
Kim
as
said-
fact as to whether there's as fact, not an issue of fact. There's
No,
question.
because as the accountant testified, when somebody takes takes a distribution to pay their taxes, that is a distribution. It's a dividend. It's profit taking from the company.
But it's not taxes for personal taxes. It was taxes in connection to the S corporation.
Well, it was it was because as the S corporation, as the profits flowed through to his own personal tax returns, he paid taxes for himself and his wife and I think one or two of his daughters. So he took profits from the company that flowed through to himself to write checks to New York State and the IRS, which is perfectly appropriate for tax purposes. It just impacted the stockholder equity calculation.
Counsel,
What about,
is there any argument to be made that Wang should be liable under the guarantee or responsible for attorney's fees or something?
No,
like that?
because as was made clear in the papers, under both 2.2 and 2.5, the two adjustments, the note balance was below zero. It was actually negative.
but she signed the
1,500.
guarantee as Wang, not as Karash, and there's no non-recourse clause in the guarantee. That was in the other agreement.
Sure.
So why doesn't she still have the potential of having to own up to the guarantee, live up to the guarantee?
She would if money was owed, but there's no money owed. Maybe I'm not understanding the question.
Well, you're saying that there's no money as far as the notes were concerned, but there was still an agreement for an amount of money that she claimed that she would guarantee, the 1 million or whatever. Usually a guarantee is when something else folds, you're paying.
Correct. So if
that's-
Carsa didn't pay the $1.5 million note, she would guarantee that payment. But the note balance went to below zero, so there's nothing to guarantee. The guarantee was to pay in the event that the company couldn't pay.
So essentially, your argument is because there was no equity left in the company, she's not liable to pay on the guarantee because there's no profits left.
No, because yes, well, two things. The stockholder equity was reduced as of the day of the purchase. And then secondly, the company did not make the required $800,000 a year in the first 3 years that she owned it. So that also reduced the purchase price. So under both the stock equity calculation and the post-closing performance calculation, the balance of the note went to less than zero. So therefore, the company doesn't owe and the guarantor, Ms. Wang, doesn't owe.
How much time was there between the time they signed that agreement and the amount of the stocks went below $750,000?
So the $800,000 is the pre-tax income generated by the company in 2017, 2018, and 2019. So it's over a 3-year period.
So in 3 years, the company went from whatever value it was worth above 1 million, I think it was 2.5 that it was purchased for, to below whatever that figure was.
Right. Well,
100,000.
the 793,000 was the equity estimated based on the
No, but it fell to almost less than half. of the original, of the purchase value.
Well, it did at the time the calculation was done. So remember, the estimate was based on the 2015 financials, and the closing didn't happen until February of 2017. So in that year and a half period, the equity of the company went down, largely in part because Mr. Kim took out $358,000 to pay his personal taxes.
The equity went out because Mr. Kim took out the money, not because of the fact that it was being mismanaged by Ms. Wang.
Correct. The mismanagement allegation.
Just asking, thank
Yeah,
you.
right, correct.
Counsel, if I may, what, if any, evidence did your client present to rebut Kim's assertion that the $358,000 constituted an asset?
That was the testimony of her accountant that was unrebutted. They didn't offer their own accountant to say otherwise. So it's really the testimony of the accountant that said under generally accepted accounting principles, when you make a distribution to pay taxes, it lowers the equity.
But it's not listed that way on the balance sheets and the records. It's listed as a receivable, correct?
In the records provided by Mr. Kim, yes.
Well, the records that we have provided to the court.
Right, but if you look at the second balance sheet, the accountant says there needs to be an adjustment and a reclassification from loan to distribution.
So on the record 1722 and going into 1725, on 1722, it's a receivable, and then on 1725, there's a hand notation that it needs to be reclassified,
Right, and
but it was never reclassified, right?
No, it was. That's the argument we make, is we said, based on what our accountant is telling us, it should be reclassified as a distribution, because if it were a loan, when would Mr. Kim pay the loan back? He already sold the business.
Thank you very much.
Thank you.
There are a few points. First, with respect to what you were asking before about the recourse loan and the inconsistency, thank you for reminding, it's inconsistent with the guarantee. So in any event, with respect to what Mr. Telesco was talking about in terms of the accountant actually did not address this issue. The accountant was a fact witness called to testify about what the intent of the parties were and how they were going to treat various issues with respect to the agreement. Mr. Bressler had no knowledge. He admitted he was not a participant in any of the discussions. There was nothing in the record where the accountant said that we have to recharacterize this as distributions. That's a proposal on a document in the record, sure, but that's not conclusive.
What is your contention that it is? Is it a receivable or a distribution?
Yes, my contention is historically throughout this company, and they had due diligence, so they should have seen this. It is listed as loan to stockholder, clear as day. If they had an issue with it, they should have raised it before the closing.
Is it still a loan to stockholder if it is to pay the stockholder's taxes?
It is, and Mr. Telesco raises a good question, as does the court. What happens to the loan afterwards? Well, we don't know. It's not in the record, but for purposes of the contract, the date that is operative is the date of the closing, and as of the closing, there is no other evidence to the contrary. It was a loan to stockholder, and it did not, therefore,
Was there any evidence that, because you're saying that in the record, if they had done their due diligence, they would have seen these loans previously?
Yes.
Was there anything in the
Yes,
record
there
that
is in the record.
indicates that the loans were repaid, and that's how we know that it's a loan?
There's nothing in the record about the repayment of the loan. There's only in the record that this was treated as a loan to stockholder in the company trial balances, both before when Mr. Kim owned the company and after when Mr. Kim owned the company. They are proposing.
The question is before, was that loan ever repaid?
I don't know, Your Honor, but I don't think it matters.
Is there a difference between the fact that it's a loan, it's not a loan for personal taxes, but a loan for taxes in connection to an S corporation?
I don't think that matters. A loan is a loan. The question is what happens to the loan, but it doesn't matter for purposes of the calculation of the stockholder equity because that's a fixed point in time.
Is it really equity if the loan is never going to be paid back?
If there's an agreement to reclassify and cancel out the receivable from the debt, and she decides to forgive the loan, yes, but there's no evidence. There's no evidence. This is the point that we've been making. These are issues of fact that should be left to the fact finder. I see that my time is up. Thank you. It's been an honor arguing before you.
Thank you. Thank you both. Highland versus MFM Contracting.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff appellate in this case. I think it's important for me just to emphasize primarily what this case is and what this case isn't. I don't see this as a traffic control case at all. I see this as a visual obstruction case. And as you know from reading our brief, we think this case is governed by 3 decisions from this court interpreting the Court of Appeals decision in Wittorf against the City of New York. And that's Florisic against the City of New York, matter of Paula D. against City of New York, and Prats against Campolo. Now, Prats against Campolo obviously went against the plaintiff, but it went against the plaintiff on proximate cause grounds. And this is what you said in Prats. This isn't Brian Isaac. This is the Appellate Division, First Department. The record contains conflicting testimony as to whether the installation of the green fence, we have a green fence here, enclosing a parking lot and or storage area on the corner, made it more difficult for drivers to see oncoming traffic and thus constituted a breach of the city's non-delegable duty to maintain its roads in a reasonably safe condition. It's true, the next sentence of that decision says that that potential breach wasn't a proximate cause based on the testimony of the driver, but I think that this court has held in Parada, in Florisic, and in Paula D. that a visual obstruction can be a cognizable act of negligence, and that's what we have here. There is no dispute, as far as I can tell from the record, Your Honors, about what this green fence did. Plaintiff said, who was going south on 9th, he said he couldn't see into the intersection. Hughes said
He never looked in the intersection.
Excuse me?
He never looked in the intersection. He assumed that it was closed. The street clearly was not closed. There was no barrier. The don't walk sign said don't walk. The green light was in favor of the car that hit him. He said he couldn't see the traffic because of the barrier, but then when he got to the point where he could have, he never looked. He just made an assumption from a block and a half away that because people were crossing the street, he could just cross the street, keep running, never look, keep his ear pods or whatever he had in his ears, listening to music, and go on.
He said that. He said he thought that the intersection was closed because he saw the obstruction. You saw the photographs. From his perspective, it would have looked like there was potentially this area being closed. And we know, although...
So is that the idea then, that people are just supposed to, not go to the corner? I mean, if everybody just went to the corner and kept crossing, he went to the corner, he sees this, like we see everywhere, construction that's where the cars might be parked, and he doesn't bother to go and peek out, see if any cars are coming. He just goes across.
Judge Renwick, you'll know from my brief, I didn't say it was a 240 sub 1 labor law case, and I certainly didn't say that the plaintiff isn't comparatively negligent, and I'm sure my adversaries are going to tell you that his negligence is so overwhelming that it constitutes a superseding cause of the accident. But I do have a response to that telling
I know
inquiry.
you do.
And that's going to be that.
You always do.
I hope that's positive, but Mr. Hughes also couldn't see. So I'm not suggesting to you that the plaintiff didn't assume that he was just going through a closed intersection, but Mr. Hughes couldn't see him also. And
He
here's
had
the
the
thing.
light. Didn't Mr. Hughes have the light?
Yes, he had the right, but listen.
The light, yes.
Oh, absolutely. It is undisputed that Hughes had the light and there was a functioning pedestrian crosswalk there. But as you know...
And no one said that he was speeding. No one said that Mr. Hughes was speeding.
No, it wouldn't...
So if you're driving, you could be going 5 miles an hour. If somebody decides to just walk in front of your car, you're going to hit them.
You will, except if you look at, when you look at the photos, you'll see that if there was nothing there, Hughes probably would have been able to see him. Also, remember the point of impact, very, very important. Hughes and the plaintiff both said that the point of impact was just at the end of the fence. So if the fencing wasn't there, and the plaintiff assumed he was completely clueless and completely wrong, he's still in the middle of the intersection. So there is a fair view of the evidence which can establish that the obstruction prevented Hughes from taking ameliorative measures that would have avoided the accident or lessened the impact. And the police officer, who has obviously no skin in the game, he thought that it was such a bad intersection and so obstructive with respect to the vision that he attributed the accident to the presence of that fence in that area. So
Well, he's
again,
no
I'm not
expert.
suggesting, I'm sorry.
I said he's no expert.
No, agreed, but he was there. Physical observations of a police officer within the scope of their employment under your decision in Holiday comes in. And the other point I'd like to make is that, I have 2 minutes, I'll just finish the thought and then I'll sit down.
Yes.
The city's governmental function defense, if you look at the motion in chief, they didn't raise it in the regular motion. As I read the record, and I'll give you the page references when I stand back up, they moved for summary judgment on the basis of the fact that the labor law doesn't apply to the plaintiff. They're 100% right about that. Your decision in Agley against Turner is correct. Then they moved for summary judgment on the ground that they delegated the function with respect to this construction to third-party independent contractors. That's 100% wrong. This wasn't raised until reply. So this is kind of a newly minted evidence that I don't think the city thought of until they saw the opposition papers. Thanks for listening to me.
Good afternoon, Your Honors. May it please the court, my name is Andrew Showers for Defendant Respondent MFM Contracting Corp.
Also, plaintiff submitted an expert affidavit basically reiterating his argument here today. In your papers, what do you do to rebut that expert affidavit?
Your Honor, we have a Canizzo expert, Mr. Canizzo, and he does, he lays out everything that was correct. He did a comprehensive review of the testimony, the exhibits, the photographs, marked at depositions. And
In those situations where we have this conflicting expert interpretation, why isn't that something that's best to go before a jury?
Your Honor, because on the facts, this is a very simple case where plaintiff ran in front of a vehicle. He did not look. He wasn't paying attention. He was running at a high rate of speed. He made an assumption that the street was closed. He was wrong. He disobeyed a stop hand.
Why doesn't that just go towards comparative negligence and not necessarily, I mean, the issue of the visual obstruction is still there, right?
I'm sorry, Your Honor?
The issue of a visual obstruction, whether or not it was there or not, that's still a thing. What plaintiff did by running forward, not stopping, that goes to maybe comparative negligence, but what do you do about that?
Your Honor, I think that when a pedestrian runs out into traffic against the VTL and against the city rules, that the pedestrian is solely responsible for the accident.
But as Mr. Isaac said, the obstruction was not only in terms of the plaintiff, but it was also in terms of Mr. Hughes, in that Mr. Hughes also stated that because of the fencing, he could not see.
With respect to the operator, Mr. Hughes, he had the green light, and a green light driver is allowed to anticipate that he can pass through the intersection, Your Honor.
With caution, though, with caution, right? There's always that caution. You don't have a right, because you have a green light, to run over a pedestrian.
Yes.
But your adversary states that because of that obstruction, because of the fence, Mr. Hughes couldn't see. So regardless of whether he had the green light or not, he could not tell whether someone was actually in the intersection, how far in the intersection, or exactly what was going on.
Your Honor, there was no effort by the plaintiff to stop at all and look. He ran right into the intersection against.
No, he didn't stop. He didn't stop when he got to a point where he could have looked, but did the presence of the green fence cause him to think at all that there was no need to stop because he thought what he saw was accurate, that the road was closed?
Your Honor,
I mean, would that not, I mean, there are two experts, as my colleague has indicated. Would that not be, even if it was 1% liability to the city for that? Is that not something that came into the equation?
No, Your Honor, because the plaintiff testified that he made up his mind 2 blocks previously that he was going to run through that intersection because he observed other pedestrians disobeying the light, the pedestrian light.
Is there a question about whether he made up his mind back there, or once he got closer and saw the green fence? I mean, was it a combination of the two? Or was it just that he decided when he saw people walking through? I mean, in other words, he testified that, okay, a block and a half, 2 blocks away, I saw people going through. And then when I got there, that green area that went into the street made it look like the street was closed. So that's when he didn't bother to look anymore.
My recollection of the testimony, Your Honor, is that he made up his mind 2 blocks previously and just continued through the intersection into the side of the plaintiff's vehicle with his headphones on, running at, 10 miles an
Did he make
hour.
up his mind because he saw the fencing and he saw the people going through, so therefore he assumed that the roadway was closed, that the street was closed?
My understanding is that he made up his mind because he saw the pedestrians walking through the light
But the
against the light.
fencing had nothing to do with his mindset.
I don't believe so, Your Honor.
Well, I mean, in terms of the testimony, his testimony was, there's nothing in his testimony which would suggest that his mindset had anything to do with the fencing.
I believe that his mindset was based upon what he saw 2 blocks prior and did not have to do with the fencing.
Counsel, aren't there triable issues regarding your client's responsibility, particularly in light of the testimony? I believe it was Mr. Mendoka, hope I'm pronouncing that correctly, that MFM, your client, was responsible for the safety at the site, along with Mr. Taylor's testimony that, as per the contract, I think your client had the discretion to decide if fabric was going to be used or not. I mean, it was your client who was going to make that decision. So don't those two things raise factual issues?
I don't think so, Your Honor,
Can you
because...
tell me why?
Yes. We complied with every element of the contract, and all of the witnesses, the city witnesses, the engineer witnesses, our own engineer retained upon behalf of our client, and the plaintiff's engineer all concede that we complied with the contract.
The contract was to use this green, whatever it was, covering, right? It's done in all projects to prevent dust or injury by a tool or something else flying into the area, right? If it
Yes, Your
wasn't,
Honor.
if it wasn't there, there would have been dust in somebody's eyes. That would have been the reason they ran into the car. Anyway, thank you very much.
Thank you very much, Your Honors.
Good afternoon, Your Honors. May it please the court, my name's Tom Fleming. I'm with Milburn, Macris, Placidus, and Side, and we represent Tectonic Engineering in this case. We were the resident engineer on this project. I know the plaintiff wants to focus on the obstruction. I want to focus on the fact that we didn't launch a force of instrument or instrument of harm under Espinal, and that's the only way we'd have even a duty to the plaintiff. Our contractual role is to look at what MFM was doing, looking at the plans that were prepared by someone else and approved by the city.
So you weren't concerned about the pedestrians and the traffic that would have been coming and going in that intersection when you thought of how the structure protecting both the workers and presumably the pedestrians was going to be constructed?
Well, even if we were concerned about the pedestrians, that's outside of our scope of our agreement. Our agreement is to make sure that the contractor is conforming to the plans.
And in doing that, the plans were that this green structure should go all the way up 6 feet or whatever it was on the fencing. Is that right?
Yes, this plans and specifications called for green fabric on the fencing.
Okay, and that was done.
Correct.
And plaintiff is saying it obstructed his view. Driver says it obstructed his view.
Right, but we didn't design it, we didn't make the decision to put the green fencing there.
I thought that there was something in the record that MFM constructed or put up the green privacy screen as directed by the engineer.
Well, correct. The engineer, so there's
You're the engineer, right?
So here's the thing, there's 2 contracts. The MFM engineering contract refers to an engineer, which is the city engineer from DDC, and then there's a resident engineer, which is Tectonic. And again, to the extent that we.
Does it distinguish that, or did I miss
Well,
it?
there are places in the MFM contract that specifically refer to the resident engineer, and there's places in the contract that specifically refer to the engineer.
Well, you were to ensure that the plans and specifications were followed, right? And you were also to conduct inspections?
Correct, while construction is ongoing. That's another key that really hasn't been mentioned here, that there was no construction ongoing at the time of this
But
incident.
if there was a hazardous condition or something of that nature, you were supposed to report it, right?
If there was a hazardous condition on the construction site involving the construction workers while construction was ongoing. Like, our contract is pretty explicit that our duties are related to when there's actual construction ongoing.
Who was responsible for the fence and the green covering on the fence? Who designed that? Who recommended that?
So per the record, MFM presented an MPT, which is a Maintenance and Protection of Traffic Plan, to the city, which the city then approved and then gave to us.
And when you say the city, it's the DDC?
The DDC, yes.
DDC, right.
Correct.
And then DDC retains you or hired you?
DDC hires us to make sure that the
construct it.
contractor is following the plan.
Hired you to construct it?
No,
No,
we're just
not
making,
at all.
we're just reporting, we're basically observing and inspecting and saying, there's supposed to be a hole
you
here.
are-
There's a hole here.
Okay.
So in your observations and your inspections, if you notice or you see that it is creating an issue in terms of individuals seeing over the fence, et cetera, is that something you would report? Have to report? Be obligated to report?
We wouldn't be obligated to report it. If it was an obvious and noticeable safety issue, we may report it to the DDC, but
Is that for the people within the area, the employees, or is that for the pedestrians you're talking about?
so that's really for the employees.
Okay,
It's really
would
for
it
the
ever be the
workers.
case? Okay, so you are saying that you were there to do safety with regard to the workers. Would there have been an instance where you would have also reported that for pedestrians?
Not that I'm aware of when work is not ongoing.
But if work was ongoing, then you would have?
Well, I mean, we really weren't responsible for site safety in general. It was just more of if we're on the site and see something that's an obvious safety issue, we might report to the workers. Like a guy not wearing a hard hat, maybe we would report that to the DDC.
Yeah, but that's a worker, that's an employee not wearing a hard hat. I'm asking you about pedestrians. And
Well, I mean, if there were no crossing guards when there were like bulldozers on the street, we would obviously say to the DDC, there's supposed to be cross guards in the MPT for this type of condition. There's no cross guards there. They should be there.
I think I understand. Thank you very much.
Thank you.
Good afternoon, Your Honors. Jason Meneses from Cornell Grace, the respondent, City of New York.
Counsel, before you jump into what you're saying, I just have one question. Does the city also agree that when the MFM contract refers to the green privacy screen material as directed by the engineer, that's particularly referencing the city's engineer?
Yes, so there is an engineer in charge. That's Mr. Taylor. He testified. So as part of the contract, MFM was required, as per the city's specs, to use some sort of fabric on the fencing. It didn't necessarily specify the specific fabric used here, but there needed to be some form of protection for both folks inside and outside the chain link fence construction
So
area.
then I guess the question would follow, why then would the city not be at some part liable for the green screen that was put up that was maybe a visual obstruction or not?
So MFM was ultimately responsible and had the discretion to make alterations to the green mesh fabric, and that's in the record testimony from Mr. Taylor and Mr. Mendonca. They both testified that there were occasions where the green fabric was removed. There were occasions where holes were cut in the fabric, and that was for various reasons based on site conditions. Ultimately, what I think the real crux of the case is here is that the green mesh fabric and the chain link fence did not obstruct the visible and operable traffic control devices for both pedestrians and vehicles at this site. So with respect to
I think
plaintiff's,
what you're saying is the road wasn't closed.
correct, the road
was
wasn't
open.
closed.
But that's not the issue. Everybody now knows, in addition to the plaintiff and the driver, that the road was open. So the issue is with regard to that chain link fence and the mesh on it, and whether or not that was an instrument of harm or contributed in some way to this accident.
So the city's position is that it was not an instrument of harm because at the end of the day, had the plaintiff paid attention to the do not walk sign, the accident doesn't happen. He could have stopped at the corner of the intersection like any reasonable person would be expected to do under those circumstances, and he could have just looked, as Your Honor mentioned earlier. And
We would
had
have
he
no
looked-
cases here.
I'm sorry?
We would have no cases in this court if everybody did what they were supposed to.
That's fair, Your Honor. That's fair, Your Honor. I don't dispute that. That's fair. Ultimately, at the end of the day, I think
Counsel, a reasonable person could have also believed that because of this mesh and inability to see past it, that the sign saying not to walk was not relevant because the street was closed because you couldn't see past the obstruction. And because a reasonable person could see it that way, there are questions of fact.
I disagree with the analysis that there are questions of fact in that regard, because at the end of the day, the plaintiff saw that this do not stop, the do not walk hand, and he chose to disregard it. This is
The question is about what he didn't see because of the green mesh, right?
It was ultimately he made an assumption based on his own subjective vision, but he was wrong, right? I mean,
See, that's the question. The question is whether or not the green mesh obstructed his view and obstructed the view of the driver. Obstructed his view, assuming he took the time to actually view the situation. Would it obstruct his view?
But I think that's the issue, right? That he didn't take the time to actually do that. So even if it may have obstructed his view a block or two back, he had an obligation at the corner to look for his own safety. So, and he didn't do that. So,
Or even at the corner, if it obstructed his view, he had the obligation to go to the end of the fence.
Correct,
is what
Your
you're
Honor.
saying. But the argument is that this was sort of, what is it? Where it appeared to be something it wasn't.
There's just simply no.
Yeah, some sort of illusion, not, it created the.
Right. It's essentially his claim is ultimately he's lulled into some false sense of security, but he has to act reasonable in the circumstances, and he didn't do that. And there's no evidence that this intersection was unsafe, other than his claim that it's unsafe because I got hit by a car. There's no evidence of prior.
It's unsafe because when you look at the photos coming up to the corner, you can't see through the green mesh. You can't see that there is a passageway for cars that way. That's what makes it unsafe.
But again, had he just looked, it resolves the issue. Had the plaintiff just looked, the accident doesn't occur.
Okay.
Thank you very much, Your Honors. I appreciate it.
Thank you.
So, counsel, should he have just looked?
Well, I'm sorry.
We know that. We can all answer that question. He should have just looked.
Judge, I'll make it easy. How's about yes, okay?
Yeah.
It's
So,
not.
Mr. Isaac, I was thinking about this. So is it your position, are there any cases, or did your expert opine that the green mesh somehow would give a pedestrian or a driver the illusion or the belief that the street was closed, or that there was that the street was closed, or that you should not proceed, or you had to proceed with caution, or anything like that?
My expert didn't do that. My expert didn't go into the plaintiff's state of mind. What he did was he said that this was obstructive, it could be taken away. What I want you to look at before you make a decision is I want you to look at the photograph and Judge Emmerich.
I've looked
No,
at
no,
the
I know.
photographs.
1176 as to the point of impact. If you look at that photograph, I don't think it would be.
I've looked at all the photographs.
I'm sure you have.
So which one is this?
This is the one on 1176 showing the intersection on the, I guess, west side of West 29th, so you could see what it looks like. And the fence looks to me to be extended more than halfway into the street.
It is.
Yes.
There's no argument that the fence is extended beyond where cars would be parked.
Right.
But it's enough for a truck to get through.
It's
Still,
enough.
it is enough for access of large vehicles.
100%. And again, I'm not suggesting the plaintiff isn't comparatively negligent, but we know from Rodriguez
But
against.
I think that the point is that your colleagues or adversaries are making is that he's solely.
Well, that I can
Because
answer.
even, you're not
Sole
even
proximate
testifying.
Yeah, so,
You're not even testifying that 2 blocks, when he's back 2 blocks, because he sees these folks crossing the street, et cetera, he thinks, oh, well, the street must be closed, and so therefore, I'm just going to keep going.
he may be completely negligent, but when you read Hughes' testimony, Hughes says he couldn't see anything to his right. This is right at the crosswalk. And the other.
And I find it also interesting, your client ran into the passenger side of the vehicle, right? The mid-passenger side?
Well, there's a little, let me be accurate. He said he was struck by the front of the vehicle. Hughes said it was the mirror, said it was the right side mirror.
Right.
I'm assuming it was probably
So
the
that means
mirror.
if Hughes had gone a little bit into the intersection, and again, when we talk about speed, apparently he wasn't going that fast, so there's not that issue in terms of Hughes speeding, but it
Correct.
seems as if your client ran into Hughes.
But that would help me. If Hughes is going 70 miles an hour, my adversaries are smart enough to say, what difference does it make? If he's going slowly and he could see to his right and he sees the plaintiff, he's going to stop. You're not going to hit somebody. As to the proximate cause issue, and then I'll sit down.
Yeah, but
I
also
don't
your
know if
client
that's
was going,
true.
yeah,
He
your
was going 8 miles an hour. I mean,
He was running.
That
He
was a
was-
pretty
he was
good
going.
clip to get into the intersection.
Look, he was training for a marathon. He wasn't running 4-minute marathons like that, but he was running for quick.
He was
8.5.
moving. Yeah, no, he was really
9-minute
moving.
miles are good.
He might have been going faster than Hughes.
Listen, Judge, all I need is a question of fact. I'll take that. The only thing I'll say is, look at your decision in Cruz against City of New York, and look at the Totoro decision in the Court of Appeals on proximate cause. City made the same argument, and in Totoro, the driver was convicted of a B felony, and they said, because the negligent act set in motion the series of events which led to accident, it's not superseding as a matter of law. There is a difference between comparative negligence and sole proximate cause. Thanks for listening to me.
Thank you. Thank you all. Thank you. Tara Labine and Whitaker versus Daniel.
Good afternoon, Your Honor. Michael Leinoff for the appellant. We have an early stage summary judgment motion here that we've appealed from. And in any early stage summary judgment motion, the movement is telling the court that there's no need to begin discovery because all of the facts that are needed are on the table. Unfortunately, in this case, that's not true. Most saliently is in the first argument, the issue was that there was a prior foreclosure sale that led us to this point.
We're aware of the facts. You should get to the point that you want to make. You have.
And in that foreclosure sale, the property was sold initially for only $100. There's no record as to why that happened. There's nothing in the file as to why that may have happened. It could be instances of malfeasance. It could be an instance of it could have been perfectly above board. The problem is that we don't know at this stage, and because we don't know, summary judgment would have been completely inappropriate to have been granted. There were certain other issues as I detailed in the papers. The action, of course, is moot because the prior foreclosure sale extinguished the debt. The court would note that in the Florida foreclosure action, the MERS as nominee of Taylor, Bean, and Whitaker was named as a defendant. Therefore, whatever Taylor, Bean, and Whitaker's rights are as to the property in the first place, in the first instance, there is no record of that either. Again, these are issues that could have been brought out in discovery, that could have been hashed out before the court extensively, but plaintiff chose to bring an early stage summary judgment motion, leading us to a position where these facts are not on the table. The last issue, of course, would be the untimeliness issue, the fact that the matter was commenced beyond the 90 days set for the foreclosure, beyond the 90 days permissible of the foreclosure sale. The court will note that there are conflicting cases on this subject, and for that reason, I'm going to conclude my comments.
Thank you.
Thank you very much.
1650 Broadway versus Sturm.
Good afternoon, Your Honors. May it please the Court, Bradley Rice of the firm Nagel Rice on behalf of the plaintiffs 1650 Broadway, Ellen Sturm, and the two related trusts. Your Honors, we submit that the motion court was wrong and made an illogical decision in 2 paragraphs, because in the first paragraph, the motion court held that because the loans of my client's son were disclosed on the tax returns and the financial statements, she had knowledge of it, and therefore there could be no claim for accounting malpractice or aiding and abetting fraud. In the very next paragraph, relying on an email from the respondent's principal partner, the motion court said and held that because Ms. Sturm did not know of the loans when they were taken, did not know any of them until 2019, her claims against her son could proceed. That is an illogical dichotomy that...
Well, on the one hand, she was speaking, the judge was speaking about, or he, the judge was speaking about the accountant, and in the other, it was the son. They're 2 different responsibilities. So she was giving the plaintiff an opportunity to replead against the son. Why was that inconsistent with what she did with regard to the accountant?
The inconsistency was, it wasn't giving the plaintiff the opportunity to replead. It was denying the son's motion to dismiss, but granting the accountant's motion to dismiss on the same issue, that they either was disclosed or it wasn't disclosed. You can't be both. And my point in the appeal is that because the respondent admitted that they never told Ms. Sturm about the fact that her son had taken over almost $12 million.
What was the role of the accountants in the agreement that it made with the company and with Sturm? Wasn't it to do the taxes, to get that done? Was there any requirement for him to actually, other than put it right on the document? I mean, accountants do tax forms. He did it. It was there for her to see, right?
Your Honor, I think one thing we have to look at is the relationship here, which is that the accountants, we've alleged in the complaint, again, this is a motion to dismiss, the accountants knew that the son was the person who was solely responsible for the day-to-day operations, that the accountants went beyond the scope of their engagement letters when they yearly had a sit-down with Ms. Sturm at her apartment to discuss the company's financials.
So that was the annual meeting?
That was at Ms. Sturm's apartment.
They had an annual meeting?
They had an annual meeting.
That's not in the written document?
Not in the written documents. The written engagement letters also include an agreement to A, comply with the AICPA code, which requires disclosures of conflicts of interest, and also their engagement letter says that if they're in possession of facts that may give rise to potential fraud, they're going to alert the relevant parties.
But counsel, I guess maybe you can explain to me, if in the financial statements, it's consistently saying that there was this loan made and to a shareholder, and it wasn't made to her, so she knows that she's not receiving the money, but it's being disclosed.
And those tax returns were sent to the son, care of the son. On every tax return that's submitted in the record, it says Mr. Kenneth Sturm, does not say Ms. Ellen Sturm, and they admit that they never told her about it. They knew that she was not getting these. She was relying on these yearly meetings.
It's her son. So what duty then goes to the accounting firm to tell her about information of what the son is doing from a financial standpoint, especially if he's charged with managing the day-to-day business? And it's in a tax return, so she has noticed that it's happening.
She didn't have notice. Again, that she, in her affidavit, said she'd never seen these.
But it wasn't in tax returns,
It was
right?
it was in the tax returns. But the son was also a client of the same accounting firm. All of the son's
What obligations did she have as a shareholder to inspect the records? Did she have any?
That, again, would be something that maybe if we were here in another year after summary judgment discovery, there would be potentially questions of fact as to whether she met her duties as a shareholder, whether she was entitled to rely on her son to present her information. But again, that's not the basis of the dismissal that the motion court had.
Back to the tax returns for 1 second. These are the tax returns for the diner, right? Where
Correct.
she is a principal. So is she not signing off on the tax returns as well?
No, it would be the tax matters partner, which again was the son, the day-to-day operations
So
manager.
the son had the responsibility of signing off on all these papers?
He had, yes, and that was the thing.
Her
The box was
signature-
in the
her
hen house.
sign-
I'm sorry, Your Honor.
Her signature did not have to appear on it? Is that what you're saying?
I don't believe you have to have
Because-
every shareholder's signature on
I'm just
the tax
asking what was the case here. Her
return.
signature didn't
I mean,
have to appear.
again, the tax returns are signed off usually by the accountant, not by the individual. You get approval from your client to file the tax returns. Tax returns can be signed off.
Right, so again, so does she not have to approve, did she not have to approve the tax returns?
She relied on her son to approve the tax returns. He was responsible for the day-to-day financial affairs of the company, and
So then her issue would be with her son, not necessarily the accountant.
Which is why the court below ruled the way that it did.
Right, but there are claims that permit aiding and abetting fraud, which we did plead here, which the court's opinion didn't sufficiently address. And independent of the son's duty, an accountant has its own separate duties to its own clients.
How did it come about that they had these annual meetings? What was that? How did that come about? And what evidence is there that they took place?
Again, this was on a plea. We pled that those annual meetings existed. I believe Mr. Getzel admitted in an affidavit he submitted to the motion court that those such annual meetings did take place. Why they took place, again, this record was not developed. This was purely a 3211 motion to dismiss. And the court seemed to be making all of these factual conclusions absent a full record of discovery.
Well, the court relied on the engagement agreement, which detailed what the responsibility of the accounting firm was to your client.
And again, Your Honor, the engagement letters also state that they have to comply with the AICPA codes, that they have to alert as to fraud. And when you have a single accounting firm serving so many different clients who have conflicted interests, we would...
You allege that you were the one, you alleged that these annual meetings took place, so what was your allegation as what was discussed or not discussed during the annual meetings?
And what Ms. Sturm stated in an affidavit was that she was provided a general overview as the diner doing well, not so well, but at no time were these loans ever disclosed to
So
her.
an accounting firm meets with the client and says, you're doing well, you're not doing well, and that's the extent of it?
That was a very high-level general view, not that your son is stealing millions upon millions
Well,
of
not
dollars.
stealing, but that there are loans and...
A balance sheet, something to show, you know, what's going in, what's going out, and why, what we're basing our statement that you're doing well or you're not doing well.
Again, that's something that the accountant should have disclosed when they met with her.
There were also allegations that the accountant may have been working in other ventures that the son was also involved in. What evidence do you have of that?
Again, we don't, evidence is, what evidence?
You made allegations
We made,
based on what?
yes, Your Honor. We know for a fact that Ken Sturm has engaged in a number of other entities. There's currently litigation pending in New
How do you know that the accountant was also working on those?
It was our understanding that that again, I think we pled that on information and belief that it was some understanding from our client that Ken may have advised that this accounting firm was handling all of his accounting. So our position is that because they were handling all of his...
But there's nothing tangible to support that they were handling all of his business affairs.
Again, we haven't gotten discovery to get all the
This is a
engagement
motion to
letters.
dismiss.
This was a motion to dismiss. We made allegations which we're entitled to do based on the information available to us. And the information available to us suggested that this accounting firm represented all the various entities were the eventual recipients of the funds that were purloined from the diner.
Thank you.
Your Honors, good afternoon. May it please the court. Rory Griebel of Fox Rothschild for Respondent Getzel, Schiff, and Pesch. I think Your Honors...
So I just want to pick up on that. This is a 3211 motion. We're at the pleading stage. We're not at the summary judgment stage where maybe things would be a little bit different, but just looking at the face of the pleadings, the allegations are there for aiding and abetting. The allegation is there for maybe the professional malpractice, that they had a responsibility as the accountants to both shareholders, not just to the son, to disclose certain information.
Your Honor, the responsibility of the accounting firm as the outside accountant is to input the information that's provided to him by the client. That is exactly what happened. The information with respect...
Is she not the client? Was she not the client as well?
She was at the meetings with Mr. Sturm every year, which was part of the engagement
No,
letter.
but you just said to input the information for the client, right? For the purposes of review by the client, right? So my question is, was she not a client as well?
She was a client, yes,
Well,
yes.
what documentary evidence do you have that utterly refutes what's contained in the complaint?
The documentary evidence is the tax returns themselves, as well as the financial statements, which noted the loan to shareholder every year. It was specifically
How does
noted.
that utterly refute the claims that there were annual meetings where the information wasn't made available? In other words, there were annual meetings where they weren't saying, there's a $12 million loan to your son who's sitting right here.
Well, the engagement letter itself.
What was the point of the annual meetings?
The engagement letters themselves.
I'm asking you about the annual meetings.
Correct.
What was the point of the annual meetings?
The annual meeting is part of the engagement letter. It discusses in the engagement letter itself saying that we will go over with you the tax returns and the financial statements, which is exactly what happened at those annual meetings.
So you're saying at these annual meetings, they told her that your son has a $12 million loan? He's borrowing this money?
That's not the obligation of the accountant. The accountant
Well, isn't that what would be gone over if you're going over the
tax returns
returns?
and the financial statements were provided to both of them and looked at by
Counsel,
both of
in
them.
the engagement letter, isn't there also reference to that the accountants will inform the appropriate level of management of any material errors and of any evidence or information that comes to our attention during the performance of our compilation procedures that indicate fraud may have occurred? Would that not be the disclosure of a $12 million loan? And then there are further allegations that the accountants were also the accountants on these numerous other businesses that the son was trying to start up with that $12 million?
Well, the actual documenting of the loans on an annual basis on both the tax returns and the financial statements disproved the notion that there was a fraud. It was out in the open. It was there for her to see. It was documented on the actual filings to the IRS.
But the accountants had knowledge of other things that weren't reflected on those statements, like the $12 million being used for 11 other businesses that the accountants were also involved in.
But I think Your Honor's put it perfectly. That's a discussion and a conversation between the principals of the company, the mother and the son, not the accountants. The accountants have one responsibility.
That goes back to my question as to whether the mother was not also a client, and therefore, as a client, whether your client, the accountant, therefore owed responsibility to her in order to ensure that she knew exactly what was going on.
Accountants under a tax engagement or a compilation or a review engagement, which is where the three engagements in this situation, do not have an independent responsibility to audit or verify the information provided to them. There was no reason for my client to know that a supposed fraud was taking place.
Okay, wait. Your client, you said, in these annual meetings, had the responsibility of going over the tax returns. In those tax returns, was there nothing about this $12 million or any of the amount going to a loan?
The tax returns document.
It's a yes or no. Was it in there or was it not?
It was in the tax return,
Okay,
yes.
so then how do you have an annual meeting and not tell somebody that there's $12 million in loans going to your son? Taken out of the business, out of Stardust, and going to your son?
She was the vice president of the company. The two of them sat down with the accountant and went over the records together. That was.
Let's add to this, because certainly they were required to provide information that, unless it was inconsequential, it says that. So certainly 12 million is not inconsequential.
Well, okay, I think we have to clarify the 12 million is aggregate over a period of time.
No.
Let's
Let's go back. 12 million is not inconsequential.
I understand that, Your Honor, and the fact
Is that a yes? Is that a no? Which one is it?
$12 million is not inconsequential.
Okay, so no, okay, so we agree with that. So let me just break it down. All right, our engagement cannot be relied upon, et cetera, et cetera, et cetera. In addition, we will report to you any evidence or information that comes to our attention during the performance of our compilation procedures regarding illegal acts that may have occurred, unless they are clearly inconsequential. So these are allegations. Did you refute that?
Yes, with the fact that every year this information.
What evidence? Where? In the record? Where?
In the tax returns themselves and the financial statements and the note to the shareholders, note 3, in those financial statements, not documenting that a loan to shareholder was made of a certain monetary amount on an annual basis. It was for everyone to see. It was out in the open. It was fully disclosed, which is what satisfies my client's obligations under their engagement letters.
So, Counsel, you just made you referenced the fact that this was, the 12 million was an aggregate? Is that what you stated?
It
That
was-
was the aggregate amount? Is that what you stated?
It wasn't 12 million all at once.
It wasn't a one loan for $12 million. It was various loans which totaled $12 million. Is that what you were saying?
It was loans made on an annual, it was loans made yearly, and they were documented.
Okay, so what my question then becomes, so that means that each year, the son is taking out a specific amount in loans. And each year, your client is meeting with the mother and not telling her that this year he took out $5,000. This year he took out another $5,000, took out another $5,000, what have you.
Each year, that information, the loan to shareholder, was documented on the tax return and in the financial statements, which is what satisfies my client's obligations under the engagement letter.
Counsel, your argument is that because you provided the documents and the paperwork, you fulfilled your obligations per the engagement agreement.
That is correct.
So you don't believe that you were required to specifically inform the mom that this is the type of money that's coming out of the account every year for loans?
There is not a AICPA statute or any statute that plaintiff has cited which confirms that concept. There is not one that exists.
Why is there an annual meeting, therefore? If you didn't have an obligation to meet with her and your only obligation was to supply the records, why have an annual meeting if you're not going to impart any information to her other than just giving her the documents?
That is something that accountants do as an industry practice to provide their clients with the returns, which the clients are ultimately responsible for filing. The taxpayers
This
responsible.
wasn't just about providing the party with the return. He didn't just go sit with her to meet with her to say, here's the return. There were conversations that took place.
I cannot personally attest
Let
that
me
I was
ask
not
you-
there, obviously.
I know that. That's why these questions are being asked. So the next question is with regard to whether or not there were allegations made, and you may not know this, but that the accountant was also the accountant on the ventures that the son was involved in. Is there evidence of that?
I have not discussed.
You represent, okay. all right.
I have not discussed that with my client with respect to the allegations because everything is upon information and belief. So I'm not sure what plaintiff is even.
So you don't know whether or not the accountant that you represent was involved in any of the ventures that the son was involved in? As the accountant on that, you don't know either way?
I don't have specifics as to what plaintiff is
Yeah, I
alleging with
understand.
respect to that.
That was my question. Okay, thank you very much.
Thank you.
Your Honors, I just respectfully would submit that our complaint does cite to specific AICPA codes that do require the disclosure of a conflict of interest when you have two clients who have adverse interests. And I think in this case where you have a son taking money out of a family business and the mother not knowing about that and the accountants knowing that he's unlikely to ever be able to pay these back because it affects her not just as an owner.
There are a lot of assumptions in that statement, right? There's an assumption that the mom is not on board with what the son is doing business-wise. There's an assumption that he's not ever going to be able to pay them back.
They're not assumptions because Mr. Getzel admitted she never knew about them. She didn't even have a chance to approve them. He just took them.
Well, she never knew about them, but yet and still, each year they're reflected in the tax returns. They're reflected in the other financial documents provided to your client, correct?
Which again, we cite to each of those documents has a cover letter addressed to Ken. They were giving the Fox the very document and knowing that what he's doing with it. And then every year met with Ellen and sat across from her with a straight face, knowing that her son was building up 8 figures worth of loans that were going into other businesses and never said a thing.
Thank you. Thank you both. Valley National Bank versus TDS Cab Corp.
Good afternoon.
Afternoon.
May it please the court, Michael Lieberman, Fox Rothschild, LLP, for the appellants Dorothy Sathros and City Transport Management. Your Honors, the Supreme Court erred in granting summary judgment, for one thing, because the Supreme Court should not have considered the defective affidavit submitted by the respondent in support of their motion. CPLR 3212B requires that summary judgment be supported by an affidavit of a person with sufficient knowledge of the relevant facts and circumstances. And
So Ms. Morisco is, I believe, who you're speaking about.
yes, Your Honor.
Her affidavit definitely includes information about Valley National Bank, and she has all of the documents, and all of that is substantiated. I think what you're referring to is that she doesn't indicate that the loans are issued by VNBNY.
Your Honor, that is part of it. But before we even get there.
Okay, and to that point, the documents do indicate all over that VNBNY is a subsidiary of VNB.
Well, it is VNB is the servicer of the loans made by VNB NY LLC. I don't know that it's a, it may be a.
On the top of the loan documents, it says it subsidiary of. Are you disputing that? Because I read.
I'm not disputing that, Your Honor, no. But what I am, my point here is that it is a separate entity, and there is no basis alleged in the affidavit for how Ms. Morisco would have any knowledge of the business or record-keeping practices of a completely separate company. And it is undisputed that they are separate. Whether there is a subsidiary relationship, putting that aside, it is a different company.
Well, you said that they're the loan providers. They're the loan servicer.
The loan servicer, but they did not make the subject loans. They're merely servicing the subject loans. And the facts and circumstances deal with loans and guarantees made by a different company. So it may be intuitive or logical to assume that someone could have access to that information or knowledge of those facts and circumstances, but I think it has to be alleged. And I'm respectfully submitting that it's not alleged here. And we cite cases too that stand for the proposition that, for example, in the Citibank case, where Citibank v. Cabrera, a second department case, and this goes to the admissibility of the exhibits attached to the affidavit, where the second department, this is a 2015 case, Citibank v. Cabrera, held that there was no foundation for the admissibility of certain evidence as business records because the affiant was employed by the loan servicer, not the lender, and failed to allege a sufficient basis for knowledge of the business and record-keeping practices of the lender, and also failed to assert personal knowledge of the payment history.
We're the first department, you know that.
I'm aware of that, Your Honor, but I think that case is on all fours and is at a minimum
Well, what
highly
about
persuasive.
Bank of New York versus Bank of New York Mellon v. Davis, where we said that an affidavit from the bank's current loan officer, who is familiar with how plaintiff serviced its mortgage loans, maintains its records and its procedures, followed by the servicer to integrate the records of a prior servicer, is sufficient?
Your Honor, be that as it may, there is still an insufficient basis in this affidavit to establish the affiant's knowledge. It still has to be alleged. It can't be presumed.
I thought she did allege, she did state her position. She said she was first vice president based upon her personal knowledge or review of the books and records which were in her possession, regular course of and practice and ordinary course of business from someone with knowledge of the transaction.
Yes, Your Honor, and I think that's exactly my point. This is so vague and conclusory. This is not establish a basis.
She also
for her
stated
knowledge.
she had personal knowledge of the manner in which the records were kept and used in the regular course of business.
But, Your Honor, a careful reading of this suggests that she's giving a litany of possible reasons that someone could have information, but it doesn't actually identify the source of any particular information. On which is it? Is it based on her personal knowledge? Is it based on shared records? Is it based on?
Based on all of that. That's what the affidavit says.
But the affiant must assert
Is it
which
your position that because it doesn't specifically say Valley National Bank, New York, inside that document, then it couldn't possibly be based on personal knowledge?
Not that it couldn't possibly be, Your Honor, but that it should be alleged, and it's not. But even putting aside the difference between Valley National Bank, New York, LLC, which is a separate company, even putting that aside, I would respectfully submit, Your Honor, that the affiant has not established a sufficient basis because the affiant has merely alleged a litany of possible ways that she could have had information, but doesn't identify the actual source of any of this information. And we cite cases that suggest that that's simply not enough. Thank you.
Good afternoon, Your Honors. May it please the Court, Bruce Goodman, the law firm of Zeichner, Elman, and Krauss, on behalf of Respondent Valley National Bank. Appellant's attack on the Morisco affidavit is a sleight of hand. Why?
No, it's not a sleight of hand.
In their
This is a, a bank, an institution asking for lots of money, and the document, those who had responsibility over the document are not there. It's the servicing company, and the servicing company doesn't even, in her affidavit, mention the bank that she's servicing. I mean, there's nothing, you don't see anything wrong with that?
In their opposition to the summary judgment motion, they admitted to the notes and guarantees are authentic. They admitted that they signed the guarantees. They admitted the borrowers failed to repay.
The question was the validity of her affidavit. There.
Right, but it's the horse is already out of the barn. If they were admitting to the authenticity of the, and it's right in their statement of undisputed facts.
If your papers don't meet your burden, why do we even need to consider what they have inside their papers?
You don't have to. That's the point. They've admitted they signed the guarantees. They've admitted they're authentic. It's right in their 19A statement. That's the whole purpose of the 19A statement. If you look at in the record, pages 230 and 231, 236.
What about your client's responsibility in those documents to demonstrate what she says? I mean, it is vague. She says everything.
Well, she says right up front, it's based on her personal knowledge. And so Valley is, pursuant to the Master Services Agreement, is VNB LLC's agent. They're authorized to commence actions to collect on defaulted.
It doesn't say VNB NY anywhere in there. I think that's what you just said. Is that what you just
said? So Valley.
VNB NY.
VNB, well, yeah, VNB NY.
Yeah, it doesn't say that anywhere.
I use my own, you're correct.
Yeah, she says upon my review of VNB's books and
right.
records.
Well, what she says is based on including records shared or maintained on computers in my possession,
shared
subject to my control,
or maintained,
or accessible to me.
Do we know which one it is? I mean, this is just so general.
It's one computer.
This is clearly done to fit every scenario. Whether it really is the one that fits this scenario, we don't know. Whether the documents are actually shared or whether they're on the computer, we don't know. I don't even know that she says she actually has seen them.
Well, she said, or from information transmitted from a person with knowledge of
to the best of my knowledge.
I have personal knowledge of the manner in which the records are kept and use them in the regular course of my business. It's in the record at 26 and 27. But the point here is, they didn't dispute that in opposition to the motion. They admitted they signed the guarantees. They admitted they're authentic. They admitted the notes were signed. They admitted they were authentic. And that's the purpose of the 19A statement, to eliminate facts. If the court were to reverse it, what facts are there to decide? They've already admitted the notes and the guarantees. That's our prima facie burden, to establish that there is a note in default that they guaranteed, and they've admitted to it. They're, after the fact, saying, oh, but her affidavit wasn't. Yeah, sure, we admit to everything, but her affidavit shouldn't have been better. But they've admitted to everything.
What's the purpose of the affidavit?
The purpose of the affidavit is to put the evidence before the court and to meet our prima facie burden. In opposition to that motion, they could have raised an issue of fact. They didn't. They admitted, yep, that's the guarantee, we signed it.
Why do we have to get to that point if you haven't met your burden because you haven't submitted an affirmation that has the personal knowledge? We don't even, it doesn't matter. I know you're saying they admitted it, and that's great. But let's talk about your burden.
Well, we met our burden. We put forward the
No, not if this is insufficient.
But they've admitted to it in opposition to the motion. So if it was insufficient when we filed it, they could have said, you're on in opposition. That affidavit is defective. They didn't do that. They could have said, those guaranteed, that note is not authentic. They didn't properly authenticate it. They didn't do that. When we alleged in the affidavit and in our 19A statement,
they raised this issue below. They wouldn't be able to raise it now if they didn't raise it below.
Correct. They didn't raise it below.
They did not raise it below?
They didn't raise the
insufficiency of the affidavit?
They took contrary positions. They raised it, but they didn't explain to the court. Well, in their 19A statement, and the court recognized it, they've admitted to it all. They admitted that the guarantees are authentic. They admitted the notes are authentic. They didn't dispute that there was a default. They didn't dispute that they didn't pay on the obligation. They didn't dispute any of that.
I think what happens here is that you provide this affidavit that's insufficient, and it's gone. It's stepped over, and it's then.
Well, it's not, Your Honor, because the 19A statement, their 19A statement is quite clear.
That they have made, and agreeing that they provided the information is looked to, not the sufficiency of the affidavit itself.
So if I may, and I know my time has expired, if I could just finish the point and respond to Your Honor.
Your thought, not a whole point. You've already
My
made the
thought.
point several times.
At the record page 230, Dorothy guaranteed the loan pursuant to an unconditional guarantee, Exhibit B, undisputed.
Thank you.
Thank you, Your Honor.
Very briefly, I just want to point out that the master services agreement that was referenced was not submitted on the underlying motion with the moving papers and should not be considered.
But what about these admissions that your adversary is saying that you made in opposition?
Well, Your Honor, even if appellants admitted to entering into the loan and the loan agreements and the guarantees, there are several other documents at issue here. For example, the documents that purport to go to the alleged damages. We've pointed to several documents that appear to just be nothing but summaries that there is no basis for whatsoever in the affidavit that appear to have been made solely for the purposes of this litigation, which would be inadmissible for that reason as well. I would also just like to briefly point out that the affiant in paragraph 2 states that some part of her knowledge is purportedly based on some shared records and or from information from a person with knowledge of the transaction actions.
It doesn't say from BNBNY. That could be from anybody, shared with anyone.
Yes, Your Honor, but my point there is that this court has held in Residential Credit Solutions, Inc. v. Gould from 2019 that where an affiant's knowledge of the facts is obtained from unnamed and unsworn employees or unidentified and unproduced work records, as here, the affidavit lacks any probative value and fails to fulfill the requirements of 3212B, and we respectfully submit that the same conclusion is warranted here. Thank you.
Thank you. Thank you both. Valenti versus MTA.
You want me to start? I thought you were first. I'm happy to go first.
Okay, I hear a lot of questions about who's starting, so I just want to make sure this is...
I am the plaintiff appellant respondent. I represent Jason Lawrence.
Right.
I'm from Fortunato and
Mr.
Fortunato.
Lawrence.
May it please the court. And
Well, just a minute, you're not starting yet. I just wanted to make sure that we were settled because I have Lawrence as first, so, okay, great. You may begin.
Thank you, Your Honor. May it please the court. We respectfully assert that the
Just note your appearance again.
Oh, I apologize. Louis Bottolato, may it please the court, from Fortunato and Fortunato for the plaintiff appellant respondent, Jason Lawrence. May it please the court. We respectfully assert that the Nisi Prius court erred in granting summary judgment on the Labor Law 200 claim against the TBTA entities, their own deponents, and the deposition of the co-defendant, Luis Mendoza, clearly demonstrate issues of fact as to control and as to failure to give the instructions they were required to give.
You're talking about the sergeant who was
Sergeant Lonergan.
told to lead the convoy, and
Yes.
the document, I think, that said that there had to be an attenuated, is that what the word?
No, that is the contract. What I'm speaking of is the deposition testimony of Edmund Knightley, a TBTA deponent, at page 2662 of the record. He testified that they were aware that the passing traffic in the other lanes posed a danger to the people in the convoy because the convoy is going so slow. Because of that, they had a responsibility to instruct the members of the convoy as to what they should and should not do, what they were allowed to do and what they weren't allowed to do. Sergeant Lonergan, at pages 3335 through 3339 of the record, goes into it in detail. He's supposed to check the ID of each driver, and when he does that, he's supposed to explain to them, you are not allowed to leave this convoy, to leave this lane. You go on the bridge with the convoy, you go off the bridge with the convoy. If you try to change lanes, it's very hazardous to yourself, to the other members of the convoy, and to the general public passing by. He also testifies...
Wasn't there testimony by another worker, I think Rob or something, who said that he was instructed by Sergeant Convoy, and it was that you speed up to get back into traffic?
Okay, that was a different deponent, but the actual driver of the vehicle that actually tried to leave, Luis Mendoza, testified he was never given instructions that morning. It was his first time driving. He shouldn't have even been driving. You can infer that his ID wasn't checked, because if it was, they would have noted he only had a permit, not a driver's license. He was actually cited for that and pled guilty to that. So he was never given the instructions, and Lonergan says he doesn't remember giving the instructions that morning. Under those facts, we now have an issue of fact as to whether they instructed, as they were obligated to do, the driver that he should not leave the convoy, should not change lanes. Now,
So is this actually on the Throgsneck Bridge that?
yes, it's actually on the Throgsneck
So
Bridge,
they're in the right lane. The convoy is in the right lane of the Throgsneck.
going at like 10 miles an hour, while the rest of the traffic is going like 40, 50 miles an hour.
Right, and at some point now, the vehicle that your client is in leaves the.
No, my client is in one of the other vehicles that does not leave.
That gets
Mr.
hit.
Mendoza's vehicle attempts to leave, cuts in front of a truck, gets hit by the truck, knocked back into my client's vehicle, which is then knocked into the stanchion of the bridge, and my client's a passenger. Many passengers in that vehicle are plaintiffs in this case, were injured in this accident.
May I just ask a question, just further
sure.
clarification? Where was this work taking place?
It was taking place on the bridge itself. They were repairing.
Where on the bridge?
Oh,
Because the
there's-
right lane was not closed off.
Yes,
So
that
where
right lane-
on the bridge was the work being done?
It was being done directly adjacent to the right lane on the actual structure of the bridge.
And the
Officer Sergeant
lanes were
Lonergan
not going
had
to be
unlock a door that gave them access to go into the actual bridge itself and do the work. They did not close the
So
lane
there
at
was
this
some
time.
sort of, if I may, there was some, once that door would have been unlocked, there was some sort of walkway or area where they would have been doing the work, where they would have been protected from the roadway? the
They would have,
traffic?
while they were actually inside that, but part of the work.
Wait, what did you say?
I said, when they were actually doing work inside the walkway, yes, they would have been protected. But the work also involved work on that right lane, which was 1 hour later closed. They would close it at
So
10
at the time of the accident, the convoy, is it going to stop at some point so that your client and others can get out and do their work?
Yes, it's going to stop on the bridge. That's why
It
they
did
have
stop.
they have an
Didn't it
attenuated
stop and actually let someone out?
Yes, the workers are getting off at different locations. It did stop and let somebody out. They then start to proceed again, and that's when Luis Mendoza cuts out of the convoy and gets hit by the truck and knocked
And
back
at some
into it.
point, it was going to stop so that your client could also get out and do the work.
Right.
On that whatever walkway next
Right.
to it.
So
And it's your argument that 200, that the means and method was controlled by the TBTA, MTA?
yes, they were the
Because
ones
they
who
were
were
responsible
for
for-
getting them safely to there. That's why they had Sergeant Lonergan in the front, an attenuator truck in the back.
And that was in the contract, a
It's in the
requirement
contract, and it's the instructions, it's a testimony, and it's the instructions that were supposed to be given, which on this day, according to the testimony, viewed in the light most favorable to the plaintiffs, was not given. Mr. Mendoza says it wasn't given. Sergeant Lonergan says he doesn't recall giving it that day.
So you're saying American Bridge wasn't solely responsible for the means and methods of what was supposed to happen?
With regard to taking the convoy out there, American Bridge makes a proposal as to what the convoy should do. It has to be, according to the testimony at 2625 to 2626 by TBTA deponent Edmund Knightley, they have to approve it, and then they give the instructions as to how it's to be done. They set up the convoy, they lead it, and they, Sergeant
Who's the
Lonergan.
they you're talking about now?
TBTA, Sergeant Lonergan.
So you're saying it was joint? The means and method, and
Yes.
who was responsible for it was joint between American Bridge and
And the TBTA, who has to approve it and then actually lead the convoy.
Thank you.
And so moving on to the next issue.
You can deal with that one on rebuttal.
Certainly.
Thank you.
I have a little spot here. Good afternoon, Your Honors. My name is Charles Kreinis. I represent Luis Mendoza and Village Dock in this matter. The trial court determined that they were liable as a matter of law solely on the issue of collateral estoppel because the teenage Mr. Mendoza got a ticket for changing lanes without signaling and paid it. He testified that he paid it. like so many other people do, because he didn't want to be bothered and he wanted to get it over with. It was never
And it's
intended.
your position that that shouldn't have collateral estoppel effect from his being able to argue that he was
It's exactly my point,
negligent
Your
or
Honor.
anything
And
else
as a
you
matter
might
of fact, all of these issues that were just discussed with the other appellant about the proper operation of the vehicles, why people did what they did, that's an opportunity that Mr. Mendoza did not have the opportunity, or would not have, based upon the trial court's decision. I rely heavily on the Court of Appeals decision in Gilbert, which emphasizes that collateral estoppel is a flexible standard that should not be applied rigidly, that you have to look at the matter below, because these lesser actions, in this case a DMV ticket, are often informal proceedings.
And that a petty infraction below the grade of misdemeanor, like traffic violations, should not be held conclusive in later cases.
Yes,
I think we have your point. Thank you very much.
Thank you.
Good afternoon, Your Honors. My name is Lisa Fleischman. I represent James Smith and Building Materials. James Smith was the tractor-trailer driver. Your Honors, we respectfully ask you to uphold the liability finding as to Luis Mendoza and Village Dock, and to reverse the findings as to the TBTA and American Bridge, which dismissed the labor law and common law negligence claims. All three of these parties are proximately caused the accident. Just briefly with respect to Luis Mendoza, he takes the position that he was rear-ended by my client and therefore my client was negligent. That is not supported by the evidence. That is self-serving deposition testimony. Mendoza was forced to admit at his deposition that there was no damage to the back of the van that he drove. My client's semi was damaged at the right wheel fender on the right side, going this way, and the van was coming this way. That's all consistent with Mr. Mendoza trying to make an unsafe lane change and striking my client. My client was not speeding. He never got ticketed. No one has ever placed any blame whatsoever on my client for his driving, and to swerve to avoid another motorist when you're driving an 80,000-pound rig on the Throgs Neck Bridge.
Are you asking us to make those questions determine those questions of fact?
No, I'm simply pointing out that the claims by Village Dock that my client was negligent are completely not supported by the evidence. With respect to the TBTA and the American Bridge, the court erred in dismissing the Labor Law 200 and common law negligence claims. It is very clear that, as Your Honor, Judge Renwick pointed out, both parties are jointly responsible for causing this accident because they didn't abide by the convoy rules. The rules were you had to stay 1 to 2 car lengths apart and drive no faster than 15 miles per hour. The entire purpose of the convoy was to not allow anybody to squeeze in. A witness named Ryan testified to that, and he's an American Bridge operative.
Ryan, I got the name wrong. I said Robert or something like that. Knew it was
So that's the whole point of the convoy, and the failure to abide by those rules allowed Mr. Mendoza to get in and proximately cause the accident. The TBTA and the American Bridge were all about controlling this convoy. The TBTA checked the IDs to make sure that only the workers got on the bridge. Sergeant Lonigan accompanied the convoy when it was necessary for him to unlock an area, a security structure on the building, on the bridge. Lonergan instructed the drivers as to where to go. The TBTA restriped the bridge span to allow for the work. You just have to find one issue of fact here, Your Honors, with respect to these two parties controlling the injury-producing activity, and I submit to you that there are many, many. With respect to Labor Law 241-6, the evidence also supports, and again, you just have to find one issue of fact here, that these defendants, the TBTA and American Bridge, violated Rule 23-1.29. It's directly applicable here and sufficiently specific.
How are they working? How are they actually working?
They were actually working. They started their workday before they went on the
were
bridge.
on the clock, so to speak.
They were on the clock.
Like their time card, but how were they actually doing the work of putting whatever things they were supposed to be putting on, the cables and everything else? They weren't actively working at the time within the industrial code, were they?
That's correct, Your Honor. However, this court has held that when something is integral to the work, that constitutes work, and that's what was going on here. The transportation to the
I
bridge...
don't think this is what this case law speaks about when it talks about integral to the work.
Well, I think it's tantamount to the cases that say that passageways to a workplace are also
That's
work
when somebody's actually engaged in the work and they're walking through and they trip over something or there's something else and they're actually doing the work.
But there's no way they could get there without
I
convoy.
don't disagree with you, but I think maybe that section doesn't apply. But I'll hear whatever else is said.
All right, I'll save my rest for rebuttal. Thank you, Your Honor.
May it please the court, I'm Stephen Johnson from Shine Johnson for the Metropolitan Transportation Authority, the Triborough Bridge and Tunnel Authority, now known as MTA Bridges and Tunnels. With regard, I would like to say it's an honor to be here in front of the five of you today. I appreciated the ceremony early. Thank you.
Thank you.
I liked what my opponent just said. Yes, Sergeant Lonergan would only be in the convoy if he had to unlock a secure area. That's the whole thing that's going on here. The plaintiff appellants are all workers that have to work in a secure area, which required Sergeant Lonergan to head the convoy, as he said he would only do if he needed to because of a secure area.
Well, that is one of the things he has to do. But
Yes.
in the contract, doesn't it also, I'm sorry, that is one of the things he has to do. But in the contract, doesn't it also indicate that they required, MTA required there to be this truck at the back of it or whatever it was, the attenuated truck? Doesn't that indicate that they are involved in the means and method of the process?
No, that contract was with American Bridge. That was delegated to American Bridge to do. They had all the convoy rules were delegated to their contractor, who was an independent contractor then, who was supposed to forward it. Let's also not forget, Mr. Mendoza was not instructed in how to do a convoy. The very simple reason was he wasn't supposed to be driving that vehicle. A different representative from his company gave their driver's licenses and was given instructions. Mr. Mendoza was not a driver known to the MTA. They could not foresee a driver switching with another driver, and that driver being an unlicensed driver who then would take out off the line of the convoy. The MTA cannot foresee that they've been fooled by somebody else having given them an ID and information. This cannot be a 200 case when the driver who pled guilty to having caused the accident, so to speak, by leaving an unsafe lane change, cannot be attributed to the MTA in this regard.
So you're saying American Bridge was responsible for getting the drivers of the trucks. So they were responsible for getting Mendoza, is that what you're saying?
Village Dock, who was the employer of Mr. Mendoza, was responsible to tell the MTA, this is my driver, here is ID. That ID had to match their driver. Mr. Mendoza was not that person represented to the MTA who was going to be the driver that day.
But didn't MTA check the IDs?
They asked the drivers to provide IDs. Mr. Mendoza was not one of those persons who gave them an ID.
Where is this referenced in the record, this allegation? You're welcome.
I'm sorry, Your Honor. I just was waiting for somebody to point out that there's nowhere in the record.
Okay, thank you, thank you. No. You will make your argument and then sit down and we speak at the podium.
I'm sorry. I would have to check my notes to see where in the record.
I saw nothing in the record, but.
It is my understanding from having worked on this case for all that time, that is what happened that day.
The claim is that Mendoza gave a false ID?
No, the claim is that every driver who was told every driver who was going to drive on the convoy had to give an ID. The fact that Mr. Mendoza says he wasn't given instruction and Sergeant Lonigan says, I don't remember him, implies that he did not provide his ID
it's an
and
implication.
get the instruction because it was not done.
But you don't know this. You're just asserting this is an
I'd have to
implication.
check the record to specifically ascertain. I do have information, and I don't want to say it if it's not in the
Just
record.
I mean, I understand it's not, it may or may not be in the record, but if Lonergan got the ID and it was just a permit, wouldn't he have had to do something at that point?
He would have stopped that person being a driver as well. You can't be, that would not be appropriate. And that was the whole person. All Sergeant Lonigan did was to check IDs to make sure those drivers were eligible to drive and give them instruction on this is the convoy. And this.
But if it was a permit, he would have known he wasn't eligible to drive, and then he wouldn't have let him drive. But if he didn't do that, then maybe there's some sort of negligence in his performance of his job duty.
The fact that Mr. Mendoza didn't get the instruction implies that he did not provide his driver's license, because Sergeant Lonigan testified to everybody that.
I don't know that you could make that implication.
I thought that Sergeant Lonigan did not give instructions that day.
Excuse me?
I thought that Sergeant Lonigan did not give the extensive instructions that day.
Well, I believe that there is, on that day, he left it for the American, I believe it was the American Bridge who actually gave it on that day, but it was still, the licenses are checked because of the secure facility portion of the bridge, which is a result of there were questions about the secure and where these things are located. I mean, it was a security measure implemented after 9/11, why there are certain secure areas, where they are, and
Thank you very
I can't
much.
get into that, though.
Thank you. And finally, it is
Good afternoon, Your Honors. May it please the court, my name is Paul Plush. I'm here from Cullen and Dyckman, and I'm on behalf of American Bridge. First, let me see if I can add some clarity to the tremendous confusion that just occurred regarding Mr. Mendoza, because there was some of what what counsel just said was correct, but I think he was missing some aspects of it. There were instructions given to the drivers every day, but on the day of the actual accident, what happened was the van for Village Dock, the employer for Mr. Mendoza, they didn't go through the process of handing in their IDs and going through the entire process of getting their normal instructions that are given by Sergeant Lonigan. What they did was, because they were a regular subcontractor on the project, they knew what time the convoys were going up. So they decided to sneak into the convoy because they wanted to drop somebody, they wanted somebody to get
Who was supposed to
onto work.
prevent them from sneaking into the convoy? Was that?
Well, I'm going to explain. So what that means is, so Sergeant Lonigan goes in first, he leads the convoy, followed by two American Bridge, one is of
minivans,
well, yeah,
some
minivans.
sort of vehicle.
Yeah, I don't know if there's a technical term, and then the attenuator truck, which is also hired by American Bridge, okay? They recognize the Village Dock truck as one of their subcontractors, and the guy lets him in because it's one of their,
okay.
They recognize him. At the time they let him in, it's actually Mr. Mendoza's uncle that's driving the Village Dock truck. When they get to this to one of the stops at the on the convoy, which they don't they just, as they're driving, they're only driving about 10.
Is all this in the record?
Yeah, this is all in the record.
Okay.
It's all testified. Everything. I promise. It's all in the record. They don't pull over. They just stop next to barriers that are there. And at that point, at this stop, the American Bridge workers, the appellants, don't get out. However, Mr. Mendoza's uncle gets out, hops over the barrier, and now Mendoza slides over into the driver's seat. Mr. Mendoza has testified there's no way anybody could have known that I was driving because we didn't let anybody know. He also testified that he wasn't part of the convoy. He wasn't paying attention to the convoy. He wasn't paying attention to anybody in front of him, only where he was going, and the fact that he was trying to get out of out of the convoy and into the traffic. That's all he was concerned with. He admitted that he had a provisional license. He had no experience driving in a convoy. That the only up to that point.
We understand.
Okay, sorry. So let me move forward, and I want to clarify also the work that American Bridge was doing on this project. They were bomb-proofing the bridge.
Yes, we know that.
On the towers. So to get there, they would go over a cement barrier, and then they had to go and get access into a security area and go up into a tower. So what they were doing was these convoys were basically a shuttle to get them to a drop-off location where they, from that drop-off
So you represent American Bridge.
Yes.
So you are arguing means and method doesn't apply to you?
No, I'm not saying that because I'm not a direct defendant. What I'm saying is there is no liability is attributable to the MTA or MTA Bridges as they're now known. I'm just going to refer to that simply because, first of all, as you earlier asked, pursuant to the contract, it was our responsibility.
So you're here taking the fall for the MTA because no one can sue you because you're the employer of the people who work for you.
But not only can nobody sue me, but the fact is that the convoy had nothing to do with the accident. The accident was solely the result of the unilateral decision of Mendoza to negligently leave the convoy. And again,
Or to have him be allowed to sneak into the convoy.
nobody let him sneak in. His uncle went in the convoy. And again, American Bridge specifically they just saw one of their subs. You got to remember, this isn't Sergeant Lonergan at the front. This is now a driver working for American Bridge, saw one of their subs, wanted to get in, and they just let in one of their subcontractors.
There has to be some kind of security. I mean, again, you're saying they're bomb-proofing the bridge. Okay, so if someone can just like sneak in and, oh, I see a friend.
This isn't
and my uncle,
somebody.
one second, and my
Sorry,
uncle, is letting me in. I got to question the security, therefore, on the bridge in terms of bomb-proofing it, right?
Well, they're not just somebody. This is one of their American Bridge hired Village Dock, and they're not in a secure area yet. They're just...
You're on the bridge.
No, they're going on to the bridge, but...
Yeah, you're on the bridge.
At this time, all lanes of traffic are open to public traffic.
And they're open to a bomb also on the bridge. That's the whole point in terms of security, the lack of security. Somebody has to be responsible for checking the IDs and making sure that only authorized personnel are in this convoy.
Okay, and that person did their job. But the fact that somebody from you want to laugh, but the fact is that if somebody from American Bridge allowed in one of their subs, how is the person that checked the IDs going to know that, number one? And number two, even if that person didn't sneak in and they showed their ID and then the other person switches over, how are they going to know? But
Thank you.
that person says they weren't
Counsel?
from the convoy. Oh,
Thank you very much.
I'm going to address the actual record, not the made-up stuff.
Counsel, you've made enough off-the-record comments. Let's just
apologize.
stick to your argument here.
Pages 335 to 336 of the record, Sergeant Lonergan testifies. It's his responsibility to make sure the convoy consists only of the vehicles that are supposed to be in the convoy. That's why he checks the IDs. He's also at the front of the convoy, making sure that the convoy stays together. They're only supposed to be one car length apart, so nobody can cut in. It's all in his testimony.
Well,
Go to pages.
what they're indicating is that not that someone cut in, that vehicle was a part of the
Somebody
convoy.
cuts in, he's supposed to stop it from
Counsel, just
happening. Oh, I apologize, Your Honor.
Please.
Well, it's not that someone cut in, that they were always a part of the convoy, but it was someone else in the vehicle that switched seats with a person whose ID was already checked.
According to their position and their testimony, their claim, their deponent's claim was that no, this van was not part of the convoy originally, it cut in. And now they're saying because it cut in, Sergeant Lonergan is not responsible. I'm showing you the testimony from Sergeant Lonergan himself that says he is responsible to make sure that doesn't happen. Then we go to page 338 to 339 and 342 of the record. Sergeant Lonergan did not recall that he gave the instructions to anyone that morning. He didn't recall giving instructions on the date of the accident. Didn't recall the last time he gave the instructions. He did not know if.
But if the uncle and Mendoza cut in, then it wouldn't make any difference whether he gave instructions or not, because they were not authorized, and therefore they would not have been present when he was giving the instruction.
Two accounts here, which raises an issue of fact. One account is that he was part of the convoy. He was always supposed to be in the convoy, and Lonergan didn't check the IDs that morning and let him go. The other account, by the people who are trying to get themselves out by blaming themselves because they can't be sued directly, is that, oh no, we just let him cut in. And so there's two different sets of testimony.
So is there anything in the record that substantiates that the uncle and Mendoza were originally in the convoy, or were in the convoy when it started out?
Yes, there is testimony that from Mendoza that he and his uncle were part of the convoy, that they waited with the convoy and that they went on the bridge. That's in Mr. Mendoza's testimony. There was no testimony from the uncle. He was never called in to testify. Additionally, there's one more issue that I didn't get to that I really want to go into right now, and that is the issue of the serious injury threshold with regard to my client. My client moved for summary judgment on the 90 out of 180-day claim. He was, by every account of anybody who actually treated him within 180 days, he was disabled during that time period, including the third-party defendants' 3 IME doctors, who they claimed were the plaintiff's doctors in their papers. And these people all determined that he was disabled from his employment and totally disabled during that time period. And he testified at his deposition that he was totally disabled, and as to what other limitations were on his life, gave detailed testimony. And this was all brought up in the original motion. They claimed that we didn't bring it up.
Yes, we have it. We've seen it.
You've seen that, so you understand that. Thank you, Your Honor.
Not one of the attorneys who spoke defended the lower court's decision to apply collateral estoppel. They didn't even use the words collateral estoppel. That was the sole basis of the motion below against my clients.
Yes.
Thank you.
Thank you.
Very briefly, Your Honors, I represent James Smith. Going back to the 241-6 claim, the work site was directly adjacent to public traffic, and we submit that that is why this provision is in effect here. The work site is a flexible concept, as this court has held, and the right lane was where work was performed. Work was performed in the towers on the cables below. Between 9:30 and 2:30 every day, the right lane was closed, and it was closed with cones and flaggers and in all the appropriate ways. And here, the workers faced the same hazards during the convoy as they did during that temporary lane closure. And as we argue in our brief, the convoy was a lane closure. It was a roving lane closure. So we submit that TBTA was negligent in not using cones and using flaggers to protect the workers during that convoy period, and that violation proximately caused the injury.
Thank you.
Thank you, Your Honors.
Thank you all. Thank you very much, Your Honor. Thank you. People versus Jamal Foe.
Good afternoon, Sam Claflin of the Legal Aid Society for Jamal Fox. The upward departure here was improper as a matter of law and alternatively as a matter of discretion. As a matter of law, there was no valid basis for upward departure because the hearing court's 3 reasons for upward departure were either fully considered by the RAI or not indicative of heightened sexual recidivism risk. First, the victim's injuries were fully addressed by the RAI. This was accounted for by the 15 points assessed for physical injury under Factor 1.
But the rape that took, I'm sorry, the robbery that took place right before the rape, I'm sorry, wasn't taken into account.
That's correct, Your Honor, and that was the 3rd basis for the hearing court's upward departure here. So to address that now, That robbery does not qualify as an aggravating factor supporting upward departure in the SORA context because it does not indicate a heightened risk of sexual recidivism specifically.
Do the guidelines allow for upward departure for if the offender poses a risk to public safety?
So the standard is, per Galati, the Court of Appeals said that departure analysis looks at over or under assessment of the defendant's risk of sexual recidivism. So dangerousness is a part of that, but our position is that it has to be considered in the context of
So
SORA.
then, yes, to my question.
Yes, sexual dangerousness and recidivism, Your Honor. So because we're
I
looking
didn't hear the last thing you said, I'm sorry.
sexual dangerousness and recidivism is the
So
focus.
you're saying that the guidelines don't take into account an upward departure for if the offender poses a risk to public safety? You're saying only if he poses a risk to commit other sexual crimes?
That's exactly right, Your Honor. That's our
Is
position.
that exactly right?
Yes, Your Honor.
And
So
what is that based on?
People v. Galati, so the foundational departure case from the Court of Appeals, says that departure analysis looks at an over or under assessment of the defendant's risk of sexual recidivism.
Well, this person, right before the other rape, robbed this woman, hit her, knocked her down to the ground. I don't know if she got away or what, but he immediately, within 10 minutes, gets another woman and rapes her right out in public.
That's correct, Your Honor.
At 4 a.m. in the morning.
That's
So
correct.
why isn't that previous action enough, given the proximity to the rape in time, enough to have that be a risk to public safety in that it's close enough in time to the sexual encounter he had?
So because the robbery was not sexual in nature, and it was part of the same, extended episode here, essentially, as Your Honor said, it was just mere moments before.
Well, it's either
Two different victims, though.
Correct.
two different victims, but
Correct.
if you're saying it's an extension, well, then it's only a question of circumstance that he ended up raping the first woman. I mean,
So there was only one rape, Your Honor, to be clear, the second victim. But our position is that the robbery as to the first victim, again, does not indicate a heightened risk of sexual dangerousness or sexual recidivism. The idea is this. The robbery was not sexual in nature. It was part of the same episode. Again, moments apart. All
But
spurred
it's
by...
not the same episode when it's two different people in two different locations. How is that the same episode?
Especially when you received consecutive time versus concurrent time for it.
That's all correct, Your Honor. But it was just blocks apart and just mere minutes and spurred by the same, drunkenness, essentially. And so the position here is that...
drunkenness doesn't always lead to rape.
That's exactly right, Your Honor. And it was a grave offense here. The point, though, is that the robbery, while not considered by the RAI, does not increase Mr. Fox's risk of sexual dangerousness
Let's talk
or
about the
recidivism
risk
specifically.
assessment, right?
Yes.
The court looked at the commentaries on page 4 under risk factor number 9, and this is the very circumstance that the commentary sort of alluded to that a court could take into account for an upward departure.
See, I don't think that's exactly right, because while concurrent offenses that aren't considered by the REI are fairly the subject of upward departure, our position is that they have to be sexual in nature. So if you look at the case, one case cited by the prosecution here, Feliciano, where there is an upward departure based on other instances of sexual misconduct, it was the fact that the other instances were sexual misconduct that was specifically the basis for upward departure. The
So upward departures can only occur when a conviction or an act is not well before, or there's not an actual conviction. And if they're only for sexual offenses, those are the only times that you can have an upward departure?
If we're relying on other conduct to be the basis for the upward departure that's not considered by the RAI, it has to show increased sexual dangerousness or recidivism. And our position is that on these facts, given that this was, our position, an extended, single episode of conduct, and the robbery here was significantly less severe than the registrable offense, that there's no additional
I'm sorry,
risk.
What was less severe?
The robbery was significantly less severe than the registrable offense here, the rape.
I thought he also assaulted her during the robbery.
And she had lacerations to her head.
Down.
Yes, Your Honor, but under the penal law, the rape offense is of a higher felony grade. That's the point. The idea is that the robbery does not make sexual recidivism any more likely than the registrable offense.
The robbery. He grabbed her purse, pushed her into a glass door. She fell and hit her head, sustaining a laceration of requiring 5 stitches. He actually pushed her into a glass door.
That's correct.
and you're arguing that that is lesser severity?
Then the rape, I mean, the penal law
Well,
considers...
yes, definitely.
That was your point.
That's
right?
exactly right.
Okay, thank you very much.
Good afternoon, Good afternoon, Your Honors. May it please the court, Jennifer Mitchell for the people. The SORA court properly adjudicated defendant a risk level 3 sexually violent offender in this case.
So let's just get to the point. Is the upward departure only warranted where there is a risk of recidivism for sexual offenses, or is the public, danger to the public also taken into account?
Absolutely not, Your Honor. You're completely correct that it's a risk to public safety in general that is taken into account here. And that's exactly what the SORA court considered when they looked at all of the circumstances of this case, including the extent of the victim's injuries here, the brazenness of defendant's actions, including committing this heinous rape out in public, as well as that violent robbery that he committed just 10 minutes prior to the rape. All of those were aggravating factors warranting an upward departure in this case because they all showed how the defendant was a extremely high risk to society, and if he were to reoffend again, could cause extreme harm. Just to really get to the point, this defendant violently pushed a stranger down the street.
So we have no question about the violence of the robbery or the violence of the rape. The only real question is the challenge to the upward departure on the basis that that the robbery wasn't sexually related.
Yes, Your Honor, completely understand. And the people's response to that is, again, simply that it doesn't matter that the robbery component wasn't sexually motivated. This robbery, as Your Honors have already pointed out, resulted in lacerations across that other victim's head requiring stitches. It was an extremely violent action taken just 10 minutes before. It led directly into this sexual assault rape that occurred, and it just is further proof of how dangerous this defendant actually is to society. And that is exactly what a SORA risk level 3 adjudication is for, is to help protect society from these type of people. And if there are no further questions, then we ask that you affirm. Thank you.
Thank you.
So again, we disagree. We think the recidivism and dangerousness focus here has to be on sexual dangerousness and recidivism specifically. Again, this is page 861 of People v. Galati, the foundational departure case in SORA analysis. So because the robbery does not show an increased risk of sexual dangerousness or recidivism specifically on these facts, it doesn't show an additional risk beyond the registrable offense alone. It's not a valid aggravating factor for upward departure here. Again, the extent of the injuries were fully considered by the RAI. The brazenness, likewise, is fully considered by the RAI. There were 20 points assessed under Factor 7 for the stranger victim, and the prosecution has cited no authority whatsoever supporting upward departure on brazenness. But alternatively, if Your Honors do want to reach the discretionary analysis for the upward departure, even if any of those cited bases for upward departure were valid, they were outweighed by the mitigating factors. Here, particularly, Mr. Fox's family support. His older brother and his mother both attended the hearing and wrote support letters for him. His brother ensured the entire family visited him while he was incarcerated and helped him financially. He had a place to stay with his mother upon leaving custody. There was no indication he had this level of family support at the time of the offense, notably. And he had additional mitigating factors as well, but we do want to focus on the family support. So unless Your Honors have any other questions about our arguments regarding the law or the facts here, we'll rest on our papers.
Thank you.
Thank you very much. It was an honor to be here today.
Thank you. Thank you both. Tantaros versus Kretschmer.
Good afternoon, Your Honors. Jay Woolman of Rendez, a legal group, joined by my colleague Anderson Duff for Mr. Kretschmer. And I'm not as tall. Mr. Kretschmer and Ms. Tantaros entered into a contract. Mr. Kretschmer performed. He was not paid in full, and Ms. Tantaros acknowledges such in the briefs and in the record below. He filed suit in order to be paid, and the fact of filing suit, which he did under seal, has been used against him as a judicially interposed affirmative defense of material breach. Of course, it was neither, the defense must be a prior material breach, and what we have here is something that was neither prior nor material nor a breach. The failure to pay preceded his filing of suit rather than the reverse. So his counterclaim for breach of contract needs to be reinstated, and her claim against him for breach of contract for the confidentiality, where the only thing determined by the court to have been a breach was filing suit, cannot be sustained.
And the suit, he filed under seal. Did he
Yes, Your Honor. In fact, the case was reported as under seal versus under seal. So what we're going to ask the court for is for the decision to be reversed. Certainly, Ms. Tantaros did not answer that counterclaim. So even separate and apart, we believe that the order of operations really should have been that she should have been found in default on the counterclaim, and that would have alone precluded her claim for breach of contract.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the court. I am Andrea Tinteros for Plaintiff Respondent Appellee. First, I'd like to address Mr. Woolman's comments regarding defendant. The case that defendant filed was not filed under seal. In fact, it was filed under an expirational seal for 7 days if I did not pay $120,000. So it was extortion, plain and simple. It had to be sealed per injunctive relief filed by my then counsel. That case was ruled in my favor in the Southern District Court and affirmed on appeal in the U.S. Second Circuit Court of Appeals. The case that we're discussing today has to deal with that same issue of breach of contract. Now, this court has already weighed in on those breach of contract claims, and I believe, Justice Renwick, you were on that panel 4 years ago to the day where you ruled in favor of dismissing 4 of his 5 counterclaims on breach of contract.
That was a different case, different issues.
Different issues, but it still goes to the heart of the
it was
issues.
this case, but different issues.
Issues of breach of contract, but also issues of copyright. And that was the case in the Southern District of New York. The breach of contract that occurred in myriad ways. Defendant posted on his social media without authorization, breaching the essential confidentiality provision of the contract. He acknowledges that in his own answers and counterclaims. He also spoke with a reporter from the New York Times about a story in which Fox News was surveilling women who were reporting sexual harassment, specifically myself and Gretchen Carlson. The reporter interviewed on December 17th, when it was published, 2017, he interviewed the, quote, ghostwriter of my book. That is the claim that Mr. Kretschmer has been making, that he wrote the book, he was the ghostwriter of the book, he owned the copyright of the book, and he was the true author, essentially writing it from scratch. And the defamation occurred, and this is the centerpiece of this case. When he penned a letter on June 7, 2016, to my publisher, HarperCollins, asserting that he was, in fact, the author of the book. He ghostwrote the entire book, not me. He demanded $500,000 in payment from the publisher. He also said that they must stop production and publishing of the book, cease and desist, in essence, and that he owned the copyright of the book, which flies in the face of the contract I had with HarperCollins, since on page 2 of the book, my name is on the copyright, registered with the Copyright Office, as determined and affirmed by the U.S. Second Court of Appeals. And so this letter created a firestorm, intentionally, littered with falsehoods, defamatory statements, known malicious lies. And it caused a firestorm because the crux of the issue gets to a man writing a woman's book who is a public figure on what it's like to be a woman facing the challenges and punching through the glass ceiling in modern-day feminism. The lower court ruled correctly when it ruled granting summary judgment in my favor on October 11th, 2019. It met all the hallmarks. A false statement was made. It was made to a third party without privilege and deliberately to cause harm. The court also granted summary judgment in my favor for breach of contract. The court also dismissed the remaining counterclaim, which essentially said that I did not breach the contract by not paying Mr. Kretschmer. And in that exact ruling, the motion to dismiss, which defendant has filed now 12 times to get the case dismissed, as recently as last week, while this court is doing its good work, ruled that that was not applicable and denied that motion, and also denied sanctions. 500 days later, and after 9 hearings with the judge on the case who issued the summary judgment ruling, after 9 hearings, that's 500 days, defendant and his counsel woke up every single day and never had an objection to the court's ruling. We had extensive, exhaustive hearings with twin motions to compel. We went through depositions, filed different motions on protective orders, all heading toward a discovery hearing on damages. How much he owed me, that was the last issue to address. And not once in all of those hearings or in any filings did defendant raise his hand and say, the court got this wrong. The court erred. There was no requisite notice of entry, and there was no motion for re-argument until a third judge was assigned to the case, and the judge at the time was not recertified. The Honorable Kathy King stepped into the case, and subsequently, the Honorable Dakota Ramser. Defendant and his counsel have engaged in a pattern and practice of now judge shopping, and after the requisite notice of entry was filed by my counsel, 500 days later, it is then the defendant decides that the court got it wrong, as we are poised and ready for a damages trial to close this chapter and finally end what has been a torrent of litigation against me for 8 years, where the court each time has ruled in my favor and put not 1 point on the board for defendant or his counsel.
Thank you, counsel. I'm sorry. Thank you, Ms. Tantaros.
Thank you. It's been a privilege.
Your Honor, I'm not exactly sure how to respond to that argument because there were quite a lot of falsehoods in there. In fact, there have been no depositions, for one. There was no extortionate threat at all. The motion in the federal court was filed under seal. Judge Seibel granted it conditionally, asking that Ms. Tantaros' counsel demonstrate a basis for it. That burden shifting is not uncommon in that sort of circumstance. So, and I should note here that the defamation claim is not actually before the court at this time. As Your Honor noted when we were doing time, the cross appeal is not before the court. The only finding, however, by the trial court for either the defamation claim or the breach of contract claim was the fact that Mr. Kretschmer filed suit. Every other allegation she has made has been rebutted by my client's evidence, his testimony and his affirmation, and the evidence he submitted in response. He did not breach contract. He did not defame her. And defamation, I should note, requires a falsehood. And my client can show, certainly, that he did ghostwrite the book. Yes, this court denied his claim for breach of a separate agreement to do so and be paid under it, but that doesn't change the fact that even he performed under this agreement and ghost wrote under that agreement the book. Now, she denies it. He says one thing, she says another. That's what a jury is for. And so all that we would ask is that it be sent back and let a jury decide what happened, because the filing of suit itself cannot be the basis for a breach of contract, precluding a claim for non-payment, because otherwise this court would set a terrible precedent. Everybody who settles a case with a confidentiality clause, and then the other side just, once they have that piece of paper, doesn't pay, now you can't sue for non-payment, it's untenable. Thank you, Your Honors.
Thank you. Thank you all. Offshore exploration versus Dijon Capital.
Good afternoon, Your Honors. Matthew Hansel of Hans & Laporte LLP on behalf of Plaintiff Appellant Offshore Exploration and Production. With regard to partnership formation, plaintiff's complaint establishes that the parties, by word and deed, formed a partnership to bid on and acquire this target company, OIG. And that's true regardless, under Texas law, of whether they ultimately sign an agreement, this collaboration agreement, that was primarily concerned with post-bidding financing logistics.
How did they enter a partnership agreement where the collaboration, the collaboration agreement was never signed? The confidentiality agreement, I believe, was signed here, but no collaboration agreement, and they kept saying that it had to be signed, sealed, and delivered, essentially. So how were they able to form a partnership?
Thank you, Justice Renwick. I think this is one of the key issues where the motion court erred in applying Texas law. And really, the enterprise and energy transfer partners case is instructive on this issue. Under Texas law, under the Texas Business Organizations Code, it's clear that no writing is required, and parties can form partnerships even if they don't intend to.
Yes, that's true, but not where they say repeatedly that there will be no partnership. There is no partnership here, and there won't be one until it's signed and delivered, I believe.
And just to add to that, there was in the confidentiality agreement a no obligation clause, right? That there was no obligation between the parties.
That's correct, Justice Weber.
No, not Weber.
Pardon me, Your Honor. Pittsburgh, excuse me. With respect to that collaboration agreement, it did establish that other than confidentiality, that agreement created no obligations between the parties. Subsequent to that agreement being entered into, there were all of the indicia under the Texas Biz Org Code that a partnership had formed. Unlike in Energy Transfer Partners, none of the agreements in this case included express disclaimers regarding partnership formation. And if you look at the collaboration agreement, the language there merely says this agreement is effective when executed. That is in stark contrast to the agreement in Energy Transfer Partners that created very specific conditions precedent specifically to partnership formation.
Counsel, if I may, so we know Texas law, the 5 factors, and when you're looking at the Texas law, you're considering the circumstances. So let's go to the complaint, and you say that there was an intent to form a partnership, but I looked at this, there's nothing there. But maybe you can point me to the paragraphs where we discuss the factors and the circumstances here.
Thank you, Your Honor. And
Justice Kennedy.
Thank you, Justice Kennedy. Before I proceed, may I briefly resolve my point on Energy Partners? And this gets back to Justice Renwick's main question. None of that express disclaimer language was here. And the Texas Supreme Court, in the Enterprise case, said that parties have to conclusively establish conditions precedent in order for a contract to obviate partnership formation under the Biz Org Code. Justice Kennedy, throughout this process, the factors began to get ticked off, all right? And
all right, so let's go to the paragraphs, because I have it right here.
Before we get there, can I just make one response to you with regard to, because you're quoting Texas law, and I appreciate that because that's what should govern here. But the Texas legislature has said that it didn't intend to spring a surprise of accidental partnership on independent business persons, and thus, quote, an agreement not to be partners unless certain conditions are met will ordinarily be conclusive on the issue of partnership formation. Here, they said in many different ways that there was not a partnership. Language was very different, but if you want, you can get back to that after you answer Justice Kennedy's question.
Thank you, Justice Renwick. And let me make it clear, nowhere in the record does any party say there was not a partnership. There is reference to we need to execute the collaboration agreement, but nowhere does anybody say there's not a
But
partnership.
they did make clear that certain conditions had to be met, and that was not done. That was what they said, and those conditions weren't met.
No, I'll address both.
But you only have a minute
your point.
37 out of your 7, I think, that I gave you, so I think
I will be quick, Your Honor. The only condition precedent could arguably be in the confidentiality agreement, said until a definitive agreement is reached, the parties have no obligations. Subsequent to that agreement, the parties agreed on a 90-10 equity split. That happened as early as September. That's record at paragraph 48 at paragraph 35. DeJohn Capital says, we have a verbal deal. We will not go it alone. That's record 51 at paragraphs 58 and 59. The parties strategized to submit offers together indicating they wanted to be partners and strategized to submit final offers to the party. That's record 52 at paragraph 60. And even after binding offers were submitted, DJ Seal still indicates we're working on this collaboration agreement. We're still going to be partners. He says that in an email.
But in fact, your Capel kept sending markups and kept changing and kept saying, if we're going to be partners, then this needs to be fully executed. I mean, there was no meeting of the minds. It seems like you're on your own part. You weren't ready to be partners yet.
Thank you, Honor. At no point does OEP say we're not partners. There are concerns expressed about, hey, we need to finalize this agreement because it includes post-bidding, and I'll briefly finish this point, Your Honor, and then I'll reserve the rest of my time. Would Your Honor mind repeating the question?
Well, I'm referring to the emails or the exchanges where they weren't ready to be partners yet. The collaboration agreement needed to be executed if we were to move forward.
Thank you, Your Honor. They had aligned on the equity split in Texas law that covers profits and losses. They'd aligned
That was a
on
90-10 split, right?
That's correct, Your Honor. They'd aligned on the strategy. They'd acted as partners. OEP had acted as a partner in disclosing key information to acquire this company. The collaboration agreement is a separate agreement from partnership formation, again, that deals with post-bidding financing and post-acquisition operations. The partnership had already been formed by the separate conduct and agreement of the parties. Thank you, Your Honors. I'll reserve the rest of my time.
Good afternoon, Your Honors. I'm Daniel Wallfish for DeYoung Capital LLC, or DJC. There was no partnership here.
Well, I was just going to ask you because I thought that your adversary just stated that no one disputed that there was a partnership.
Pardon?
I thought your adversary just said no one disputes that there was a partnership. And I thought that that was the whole gist of this case, was that you are disputing that there was a partnership, are you not?
Yes, Justice Weber, absolutely disputing it. Partnership under Texas law has to be based on some type of agreement. And so a court looks to principles of contract formation, and a court can look to principles of partnership formation. Here, as several members of the bench have pointed out, the minds never met on the terms of their arrangement, and the no obligation clause sets out a condition that's not satisfied. In this case,
The information was being shared, right? You know, information that would be vital to the partnership moving forward for the purpose that the partnership would be created.
absolutely, Justice Pittsburgh, and that was the purpose of the CA. Which
Your client was holding himself out as a partnership when.
Pardon?
Your client was holding themselves out as a partner when conversing with.
No, Justice Michael. The parties were both going out of their way not to do so. They kept saying in their submissions to B of A, if we are allowed to partner. And as for the question of whether OEP denied a partnership. That question came up just now from the bench. They did so. OEP itself denied the existence of a partnership repeatedly, and we have a bunch of cites for this. I think it's at page 24 of our main brief. It's all over the record. He's like, we need to get our partnership agreement finalized. I'm not ready to execute. We're still far apart. This is on page 24 of our main brief. I won't, unless the court wants me to, go into the actual pages of the record, but they're all set out there. There's not one, so in addition to the fact that the ETP case from the Texas Supreme Court is not distinguishable, the no obligation clause there is essentially the same as the no obligation clause here. The parties agreed that they were not going to be bound until they had both executed a written agreement. My opposing counsel's description of the purpose of the collaboration agreement is simply not accurate. That was what the parties were talking about as their potential partnership agreement.
What about the fraud claims?
Yes, thank you, Your Honor. On the cross appeal, the fraud and promissory estoppel claims are not, they should have been dismissed. First and foremost, reasonable reliance fails as a matter of law. It is black letter law in Texas as in New York that when parties agree not to be bound to transact with one another until there's an executed written agreement, it is unreasonable as a matter of law to rely on your counterparty's oral or informal assurances.
What about out-of-pocket? Maybe not the benefit of the bargain, but what about out-of-pocket damages?
No, Your Honor, because the fraud claim itself fails. So yes, they're limited to out-of-pocket. If this court were to rule that the fraud claim...
And why wouldn't there be a fraud where here this DJC said the entire thing, I'm not doing anything without you. I am not going to bid without you. I'm not going forward without you. 10 different ways.
Well, it's
said, don't worry about it. I am not going to bid without you.
Yes, Justice Rennick, I understand the court's question. It's not 10 different ways, but there's 3 reasons why. The first reason is reasonable reliance is unsatisfied. We have a series of cases on this on page 42 of our main brief under New York and Texas law that if you've already agreed that you're not going to be bound until there's an executed written agreement, it doesn't matter if your counterparty gives you some form of informal assurance, like, oh, we have a verbal deal. In fact, that exact fact pattern has been treated in the Texas case law. The Chalker case, to which, by the way, they have no response, considers an actual situation where
why would those statements not lead the plaintiff to believe or to rely on those statements, and therefore, as plaintiff alleges, their reliance led to a missed opportunity to obtain a partner,
right,
another partner, according to them?
Justice Weber, I understand Your Honor's question. I was speaking, which I will address in one moment, but I was speaking to the reasonability of reliance. So you cannot reasonably rely, again, where there has to be an executed agreement. And they don't dispute that legal principle. I want that very clear. Their brief does not dispute that that's the black letter law. And so to Justice...
Are you making a distinction between reasonable reliance and justifiable?
Reasonable and actual, Your Honor. So those are distinct under Texas as under New York law.
Don't disagree with you. What
Yes,
about the
so
justifiable reliance?
Pardon?
What about the justifiable reliance?
Well, justifiable and reasonable are the same, but then you have to have actual or detrimental reliance. You have to have actually relied to your detriment. So my first point was about reasonable reliance. Justice Weber's question is about actual reliance, which also is unsatisfied. OEP kept saying there's no agreement in place, and he kept redlining the draft agreement in extensive and highly material ways. And then...
But in that same time frame, wasn't information still being shared freely?
Absolutely, Justice Pittsburgh, and that is exactly what the purpose of the confidentiality agreement was. I know I have very little time left, but the confidentiality agreement specifically says that its purpose is to allow the parties, and this is at Record 81, quote, to determine whether they wish to enter into a potential transaction with the other party. That was the whole point, was to facilitate exploratory conversations. But until both sides had signed on the dotted line, there was not to be any agreement. And it doesn't matter if orally he's like, hey, we have like a verbal deal. That's the reasonable reliance. So
my question was, why would those statements about we're not going to go it alone, we're with you or what have you, why would that not lead to some type of justifiable reliance by plaintiff?
Because
it's going to occur?
Because this court and the courts in Texas have already said you can't justifiably rely. If you've already agreed there has to be a written agreement.
This is a motion to dismiss. Why shouldn't be reading the pleadings in the light most favorable to the plaintiff, to the movement?
Because, Justice Renwick, the principle that I'm citing, for which we have citations, and again, they don't dispute the black letter law principle at page 42 of our brief. Those are all motion to dismiss decisions from the First Department, which of course has the 3211A1 procedure that factors in documentary evidence. The relevant documentary evidence here is the no obligation clause in the confidentiality agreement, plus as well the endless drafts of a collaboration agreement that said in 3 different places each and every time it won't be effective until executed. And the final reason, if I may, I see my time's expired, but I want to finish responding to Justice Weber's question about actual reliance. He put in 3 bids of his own directly, and he did so according to his own complaint, quote,
Except that he would have put a bid in with someone else had he had known that this wasn't going to work.
He did know that he couldn't rely on it.
He put a bid in on his own, but he would have put a bid in with someone else and sooner. He gave all of his confidential information to this other person who used it all, to DJC, who used it all without him. I mean, he would have put a bid in with someone else. That's the alternative.
That type of speculation.
That's what he's indicated, that he would have put a bid in. If he knew that this person wasn't going to do the deal with him, do you think that he would have given all of this information, privileged information, to him?
Well, Justice Renwick, I know that
Can you answer that question, please?
Uh,
You have to speculate.
He didn't.
Because everybody would turn over all of their documents to someone, knowing that that person's going to turn around and not.
The court appears to be focused on the theory that DJC misappropriated confidential information from OEP.
I'm focused on the theory of reliance.
But Your Honor.
Thank you. Your time's up.
Briefly, Your Honors, the court is absolutely right. We're here in the context of a 3211 motion. None of the evidence utterly refutes plaintiff's allegations. The confidentiality agreement says a definitive deal has to be reached. After that agreement was signed, DeJong said, we have a verbal deal. And that was after the parties submitted non-binding offers saying, we're going to partner with the other party. Reliance is addressed, and I'm glad the court pointed it out. Throughout the whole process, anytime OEP raised a concern, it was met with a reassurance from DeJong saying, we have a verbal deal. We're not going to do this deal without you. Statements specifically designed to assuage any concerns that OEP might have that this deal wouldn't be done without them. And this is in the context of OEP having truly unique information about OIG because it previously owned and operated it. There is no way this deal gets done by anybody if DeJong Capital doesn't have access to OEP's understanding of the inner workings of OIG. And we know that because early on in the process when DeJong was involved solely, the seller threatened to kick him out of the bid process because he was making zero headway. It was only after DeJong got together with OEP and they started collaborating and strategizing on the bid strategy, the basis of their partnership, that they began to make headway with the sellers. Again, Your Honors, nothing in the record refutes the idea that there was a partnership here. Nowhere, if you look at Brent Callop's emails, does he say we don't have a partnership? He's concerned we got to finalize this agreement that says how we pay for it and deals with post-acquisition operations. The only reason OEP would go up to the final bid process with DeJong, strategizing on the day before final bids are due about, hey, are we going to submit a joint bid? Are we going to submit separate bids? Are we going to do all 3? Is because OEP believed and DeJong told them they had a partnership. Your Honors, thank you very much for your consideration. Justice Renwick, it is an honor to be a visitor in this court. It is a beautiful courtroom, and particularly so on this day before this panel. Thank you.
Thank you very much.
Briefly, Your Honors, DJC never said they were partners. It's nowhere in the record, and OEP kept denying it. I understand, Justice Renwick, Your Honor's question to me, and the short answer to it is that the motion court, Justice Reed, sustained the claim for breach of the confidentiality agreement. Now, on the facts, we dispute that there was any confidential information that was shared, let alone misappropriated. But I'm mindful that the court is mindful that this is a 3211A motion. That said, to the extent that the concern is that confidential information really was shared and was misappropriated, that's why he has a cause of action for breach of the confidentiality agreement. But I do want to reiterate that reasonable reliance, actual reliance are not satisfied. And on top of that, there's another point we made in our brief, but that the promissory statements, he believed them at the time. I won't do this deal without you. He believed that. He thought that, he said, I'm not trying to go it alone, and that was all true. And that was all before OEP at the 11th hour gave him a red line that ripped all the prior drafts of the collaboration agreement to shreds. So he has to have alleged, and he didn't, that we lacked an intent at the time that we made our alleged statements not to fulfill that promise. So if the court has no more questions, I think I've finished, and I thank the court very much for your
Thank you. Thank you all.